Thanks. We have a full schedule today. We'll be starting with Senate Bill 216, and our senator is here to introduce that.
Good morning, Senator French.
Good morning.
How are you?
Doing well.
Notice I'm chocolate.
Yeah, you're nothing.
That's right. Hello, rest of committee as well. Good morning. For the record, I am Senator Rebecca Perkins-Quokka from Senate District 21, representing the city of Portsmouth and surrounding towns. I'm the prime sponsor of SB 216, establishing a committee to study the landlord and tenant mediation program in circuit court. SB 216 will create a commission to study the landlord-tenant mediation pilot program currently ongoing in the circuit courts. Working with Judge David King and his staff, Margaret, who's here today, the circuit courts have developed this new program in order to work through issues between landlords and their tenants while trying to avoid evictions. We all understand how important housing is, especially after the last year and a half, and SB 216 will give the general court and all relevant stakeholders an appropriate venue to analyze the program, assess what has worked and what hasn't, and make recommendation for changes in the program going forward. Mr. Chairman, thank you for the opportunity to present SB 216, and I'll be happy to answer any questions.
Thank you, Senator. Any questions?
Hi, Senator Perkins. Good morning.
Senator.
Question for you. Nothing like last week. Tenant mediation program. How's it going?
From what I understand, it seems to be a great success. So I think that Mr. Head and Ms. Swanger are here from the court to answer specific questions about the statistics. But from what I hear, the program's been able to keep up to 80% of tenants in their home, and it's been a successful venue to really let landlords and tenants, air any sources of friction between them, work out plans, for example, on payment or resolving other issues. And as we all know, the vacancy rate is so low for housing around the state that being able to keep someone in their home is a really critical success that this program's been good at.
Thank you very much.
Yeah.
Thank you. Anyone else? Seeing none, thank you, Senator.
Thank you, sir.
Margaret.
Good morning, Chairman French.
Good morning.
And members of the committee, good morning. My name is Attorney Margaret Huang, and I am the Alternative Dispute Resolution Coordinator for the New Hampshire Judicial Branch. I am testifying today about the current landlord-tenant programs that the Office of Mediation and Arbitration oversees. We have two types of programs. One, a pre-filing program, which offers mediation statewide before a court case has been filed, and two, a post-filing program, which offers mediation in Concord, Manchester, and Nashua after a case is filed, but before parties go in front of a judge to have a hearing in their case. Both are funded in part by a grant from the Governor's Office for Emergency Rental Relief and Recovery. In mediation, landlords and tenants have a space to talk to each other about what is important to them, to try to understand each other, and to plan for the future. Whether the outcome is for the tenant to continue living in the unit, for parties to apply for rental assistance with the community action programs, or for the tenant to transition out of the unit. Because mediation has few barriers to participation, self-represented landlords and tenants are able to talk about the issues without needing to understand complex and technical court procedures. Mediation gives landlords and tenants the opportunity to take control of their situation because an agreement is reached only if everyone agrees. As opposed to being adversaries in court, they're problem solvers, and mediators can lead people to creative solutions that would otherwise may not be available. In our pre-filing program, we are able to provide assistance to people even before a landlord-tenant writ is filed. If an agreement is reached, this means that the landlord has saved the expense and hassle of filing a court case, and the tenant has avoided the black mark of having an eviction case filed against them. During intake, we listen to the caller's account of the situation, tell them about the mediation program, and also refer them to resources that may be applicable. Through this program, we are able to connect landlords and tenants to resources available to them and provide a space for landlords and tenants to resolve their dispute without the need for a formal eviction proceeding. In our post-filing program in Manchester and Nashua, mediation is offered at the courthouse on the day of the landlord-tenant hearing on the merits. Representatives from Southern New Hampshire Services and New Hampshire Legal Assistance are also present, and landlords and tenants are able to access the services they wish and can choose to access multiple programs. In offering mediation, along with access to these other services, we hope to assist in creating win-win solutions that benefit all parties. And lastly, just to end, is feedback from the parties themselves. Over 93% of people who responded to our voluntary feedback survey after mediation have stated that they were treated fairly, understood the process, and would use mediation again if needed. Thank you. I'm happy to answer any questions.
Thank you. Could you tell me, are these mediation programs mandatory for the landlord to
No,
participate?
they are voluntary for both
Great.
parties.
Any questions? Seeing none, thank you very much.
Thank you.
And Alyssa? Pardon me? Alyssa Margolia? Oh, I'm sorry.
I'm not speaking. Housing Action is in favor, but not
Oh,
speaking.
not speaking.
Yeah,
Great, thank
yeah.
you. Anyone else wishing to speak on Senate Bill 216? Seeing none, I'll close the hearing on Senate Bill 216. If you want to, we can.
I'll move executive session.
Second.
We have a motion of executive session by Senator Bradley, seconded by Senator Susie. All in favor?
Aye.
Opposed?
I'll move on to pass.
On to-
Second.
We have a motion of ought to pass on Senate Bill 216 by Senator Bradley, seconded by Senator Susie. All in favor?
Aye.
Opposed? We have a motion of consent by
Consent.
Senator Bradley, seconded by Senator Susie. All in favor?
Aye.
Aye.
Opposed? Thank you very much.
Who do you want to take that out?
Senator Susie will.
Okay.
And we have a motion to come out of executive session, seconded by Senator Susie. All in favor? Aye.
Aye.
Thank you. 2 minutes. You got 2 minutes. Anyone here for Senate Bill 249? Ha, okay, thanks.
We're not going to do that.
It's been delayed.
Thank you very much. Anything you do. Yeah, I like Thursday. And maybe not Sunday, because you don't have to. Whatever you do. Okay. I'll go put a draft something. Sure. Yep. The rest of it, I think, stays the same. Yeah. Harold would let them work till 4 in the morning, but.
Oh, yeah. Oh, yeah. Constantly.
I might feel different if my kids would send me some of the money home. They'd keep it all. You know, like city kids who turn it in, right? Don't they turn it into the family?
Yeah,
Is that what your kids did?
I don't see that.
Elevator music.
We should. Do we have a coffee fund? Yeah, a lobster. Except the lobstermen are mad at me for my lobster trap bill. Yeah.
Oh, I never got back to you. Second hearing went fine on Thursday. When you
Oh,
skipped-
did it?
Skipped out hours early, so that's fine.
Yeah, but, yeah, how long did it go for?
Went to almost 7. When did you leave?
4:30?
I was very nice.
Wow.
That's
I had heard enough.
It's a different bill.
No, I mean, that one I was against anyways.
I understand.
I think Bradley's good.
Huh? Yeah, that's right. I'll open the hearing on Senate Bill 217, Senator Perkins Quokka, to introduce her.
For the record, I'm Senator Rebecca Perkins Quokka from Senate District 21, representing Portsmouth and the surrounding towns. I'm the prime sponsor of SB 217 relative to eviction notices. SB 217 is a piece of legislation that I'm working with New Hampshire legal assistance on, and Elliot Berry will be here today. SB 217 will expand the minimum amount of notice needed for certain renovation evictions from 30 days to 90 days. In such a tight housing market, with vacancy rates hovering between 0.5% and 1% around the state, it can be next to impossible to find housing in 30 days with the threat of an eviction hanging over your head. This bill is designed to provide additional notice for tenants in cases where a landlord evicts a tenant prior to the end of their lease for a few discrete situations, substantial renovation, or sale of their property. In New Hampshire, we are lucky to have small local landlords, and everyone has an interest in preserving that. This bill is designed to provide some balance in the needs of landlords and tenants and make sure that tenants are able to relocate their whole lives, their homes, and their commutes within the time given to them. You'll hear testimony today from both Elliot Berry and Nick Norman, who's representing the landlords and the tenants. I reached out to Mr. Norman actively to hear his concerns on the bills, and I am discussing those concerns with Mr. Berry. It's our intent that this bill end up as narrow as possible to respect the needs of landlords while also recognizing that in these extreme circumstances, it is very, very difficult to find housing within 30 days. I hope this bill will give individuals and families already facing an already dire situation just a little bit more time in which they could either find a new place to live or find a system to help them catch up on payments or find another avenue for staying in their home. We all know the lack of long-term housing supply is the real underlying problem here, and one I have been working on for over a decade. In the short term, however, over 50% of our renters have already experienced COVID-related job loss, and we need to continue to ensure they can stay in their homes so they can get themselves and their families back on their feet. Mr. Chairman, thank you for the opportunity to present SB 217, and I'd be happy to answer any questions.
Thank you, Senator. Any questions? Seeing none, thank you very much.
Thank you.
Chris Norwood?
Good morning, Mr. Chair, members of the
morning.
committee. My name is Chris Norwood, and I am the 2022 Public Policy Chair with the New Hampshire Association of Realtors, and I'm speaking in opposition of Senate Bill 217. 3 points that I had, one being a little bit of a confusion issue relative to line 7 in the bill, relative to the inability for a landlord to evict a tenancy if their desire is to sell a property. So from personal experience in my brokerage of commercial real estate and investment property, I rarely have I seen a landlord proactively evict their tenancies to put the property on the market, or while the property is actively under agreement to a prospective buyer having a desire to evict tenancies. And simply put, it's because one never knows if the property is going to transfer until it actually gets to the registry. And so a landlord proactively evicting their tenancies, it just doesn't happen, because if the buyer ever backs out, there would be no recourse, and the seller would have an empty building and mortgage to pay and taxes and so forth. So a little bit of a confusion on that piece of the bill. More specifically, when a buyer comes in and is asked to renovate a property, whether it be for code violations or just an upgrade of the property, typically that buyer is going through a renovation loan. And that renovation loan typically has some time constraints on it, whereby they have an interest-only period that will convert to a fully amortizing loan after so many days. And the concern we have is there's a 90-day window here, so there's an added 60 days from a current 30-day notice, which is typical. So we're bringing that to an extra 60. And what impact does that have between the new buyer and their lender? Also, I will say, though infrequent, there are sometimes code issues that would impact insurance. And these are not necessarily mandated by the municipality, but come up during the discovery process of due diligence. For example, you have live knob and tube wiring. And unfortunately, I've seen cases where this happens, and the remedy, should the seller not choose to remedy it, is for the buyer to take title to the property and then remedy that. But they have an insurance product, which is a very limited window in which you can convert that live knob and tube, which may or may not necessitate evicting the tenancies while that happens. So those are a couple, more technical challenges. And I think most broadly, we're looking at this bill as to say, the remedy that a current tenant has if they have concerns relative to their property selling would be to collect a lease and get a longer-term lease. And there are benefits to having a tenancy at will for both landlords and tenants, the 30-day tenancy. There are benefits to both sides, and we just feel that there should be symmetry, and this bill would create an asymmetry where the landlord has to provide 90 days, but the tenancy, in this example, would only have, the tenancy would still be able to get out with 30 days, and the landlord would have to provide 90, and there's just an imbalance there. So the remedy would be to seek a lease, and then both sides are protected in that example. Thank you for your opportunity.
Thank you. Would this cover single-family and two-family homes also for tenancy?
So I'd have to go back to RSA 540, Roman numeral 2, and whether or not that covers the, okay, I'm getting the head nod no.
It's only
5 units?
The restricted,
yeah,
yes, thank you. So yes, it would be for just the larger,
4 units or
4 units or greater.
Okay, great.
Thank
Thank
you,
you.
Senator, for helping me.
Thank you, Senator. I meant to ask you, but anyone else with a question? Seeing none, thank you very much.
Thank you very much.
Elliot Berry?
I have some handouts for the committee.
Great, thank you. Just hand them.
Good morning, Mr. Chair.
Good morning.
Thank you for this opportunity. My name is Elliot Berry. I'm the co-director of Housing Justice at New Hampshire Legal Assistance. I've been representing quite frankly and openly, tenants for over 40 years. I have extensive experience in the courts and actually in this legislative process. I just want to, again, very, very briefly talk about the background for here. We are in a market condition, which my first handout is, that shows a median rent for a two-bedroom apartment is $1,498 a month with a vacancy rate of less than 1%. Over this time, we've seen at legal aid, we've seen a major spike in evictions for things like rehabbing the property and selling the property. And yes, I have seen eviction notice that says landlord wants to sell, and that's the reason for the eviction. Quite frankly, I think sometimes that's just pretext. They have other reasons, but I think but we have seen a big spike at a time when tenants simply have an incredibly difficult time finding a place. But I also want to make clear that this is not just for our current emergency situation that we have in the market today. As I said, I've been here for more than 40 years practicing, and only twice has there been what they call a healthy vacancy rate. And that is during the savings and loan meltdown in the late 80s and the Great Recession in 2007. Otherwise, the market has never been producing enough housing so that people of lower income have a reasonable chance to find another place in a relatively short time. Again, before getting into the details of the bill, two essential points. Number one, this is not about bad actors. As I just alluded to, there are some bad actors out there who have clearly used sale or renovation as a pretext for eviction, because it's incredibly hard to prove that it's not true and easy to allege. But for the most part, it's not about them. The other thing that, again, I'm glad just got clarified, this has no effect whatsoever if you are the owner of a single-family home and you don't own more than 3 at any one time. It doesn't affect you. If you live in an owner-occupied unit of 4 units or less, it does not affect you. If a bank takes by foreclosure, it does not affect you. What does the bill right now under our current regime? Landlords can evict on 30 days' notice for what they call other good cause, along with a laundry list of the typical reasons that people get evicted. One of the other good causes right now that requires 30 days that's commonly used is the landlord wants to renovate the property, or the landlord wants to sell the property in a vacant condition. This bill would extend that notice from 30 to 90 days. Why? Because in 30 days, my clients, lower income tenants, have no reasonable likelihood of being able to rent an alternative place. And the 60 extra days hopefully will make a significant difference. Again, in terms of when the landlord needs to sell, most of the time, when there's this really compelling need to sell, it's going to be this non-restricted property, right, where it's not affected by the bill. If you're selling a multifamily unit and the tenant and a place needs, and you're going to sell it, why kick the other tenants out? Because in fact, the new buyer is going to need tenants. So that shouldn't be a reason to evict somebody on short notice, remembering that the tenant here has no fault whatsoever when they're getting evicted. A lot of my clients over the years who face this problem, elderly people who have for decades lived in the same apartment. The owner sells the place right now. The new owner wants to renovate, and after decades in the same apartment, this elderly person has to go out in 30 days and find a new place, or you go through a traumatic eviction process. There has been concern about the bill that the that when you add the actual court process to the 90 days, it could take as long as 120 days. Let me suggest this, that if you give that the eviction notice gives the tenant 90 days, some of those people will be able to get a new place by the 90th day so that the eviction process doesn't even have to happen. And in that way, yes, some will be dragged out longer, but a lot of them won't, because the 90 days will make a key difference. Another interesting issue that's been brought up by some of the opponents of the bill is that during the time where between when you first get the notice and when the tenant finds a new place, they're going, for those 3 months or whatever, the tenant's going to have to pay double rent. That's simply not true. Most of my clients, by the way, don't have leases, and if they find a new place, sooner than they're not going to pay double rent. They can leave. The other interesting thing is that for tenants who do have leases, let's suppose that you get that 3 months before the eviction process begins, the landlord gives a 90-day notice that ends at the date of the termination of the tenancy. The tenant finds, and so the tenant has gotten an eviction notice. And the eviction notice, what does it say? And this is the official court eviction notice, which I've included in the materials here. The eviction notice says you must leave on or before the date specified in the notice, which means the tenant has been directed to leave before the lease expires, and they're not responsible for the last couple months, because the eviction notice says you leave on or before then. So let me just point out a couple more things in the packet I gave you. One of the supporters here is a copy of an email that's been sent to all of you already from Paul Stewart, a property manager who owns over 250 units. He is in support of the bill because it is the fair thing to do when somebody is being kicked out of their home through no fault of their own. Let me also, there's also 2 other letters in there, but I also want to suggest an amendment for you, if you're at all interested in this bill. In talking to Mr. Norman, I did recognize that there may be situations where, another situation where this should not apply. And that is, do you mind if I pass this out to you?
No, just give them to the, Aaron.
So the amendment would add, if you look at if you go down to look at the line 23 of the bill, the amendment would give another reason for only keeping 30 days, as it is now, to evict the tenant. And that amendment would be that the dwelling unit requires repairs which can't be performed while the tenant remains in the residence. And those repairs are required for the health and safety of the tenant who's living there or other tenants in the building, or those repairs are required to prevent the deterioration of the dwelling unit or other dwelling units in the building. So that's the third exception. So there are clear cases where the 30 days is regrettably necessary, and I think I've covered them by virtue of the amendment if you choose to take action on it. Finally, let me just say that lines, to avoid any confusion at all, lines 19 through 23 add absolutely nothing to the current law. I'm not sure why Legislative Services threw it in, but those provisions, under current law, a landlord can't evict somebody because of lead, just because, without complying with RSA 138. And the other one is landlords are currently prohibited from retaliating against tenants for making good faith complaints. That's not a change. Those parts of the bill don't make any changes at all. So again, it's regrettable that the bill is necessary, but if we want to attack homelessness, I think it's just something we have to do. I can't tell you how many people just have just been utterly traumatized by the receipt of a 30-day notice because of renovation that's not their fault and getting thrown into this market. With that, I'd be really happy to answer any questions.
Thank you. So how does the process work? If I want you out of my unit, I give you a notice that I want you out.
An eviction notice, that's correct.
Do I go through the courts for this notice, or do I just give you a notice to quit?
On the court website, there is, for any landlord who wants to use it, there is a standard form, and it's actually the form it's in that packet that I gave you. And then the law requires that if you don't use that standard form, the eviction notice that you do use has to contain substantially the same information. And then when that eviction notice expires, then the court process kicks in.
So then, I've given my tenant a notice to quit in 30 days. 30 days, they're not out. Then I start with the courts.
That's correct.
And how long does that take?
In one of these evictions, for renovation or sale, that's going to take, if there's in most cases, that'll take 3 to 4 weeks, about 4 weeks more.
To get into court?
No. To actually have your court hearing. Probably 3 weeks. And then the writ of possession that the client gets issued, that the landlord gets, is 7 days after the court rules in their favor. The court does have the opportunity to grant the discretionary stay. Sometimes they do that, but.
And then, is there an appeal process to that?
The only appeal is to the state Supreme Court, which is an extremely difficult appeal. And one other thing about that, the vast majority of tenants are not represented. Vast majority. Plenty of landlords too, but because they do this over and over again, they know the law generally pretty well.
So it could be another 6 to 8 weeks to have a tenant actually out of your unit from the 30 days you give.
That could be, but remembering also that a lot of tenants will do everything they can to leave. But yes, that's true.
So that process, if this passed, that process wouldn't even start for 90 days, is that correct?
Correct.
Okay, great. Any other, Senator Bradley? No. Senator Gannon?
Yeah, just a couple of quick things. Thank you for taking my question. So part of the reason you feel that we need this is because you're saying the landlord is more sophisticated, he has a more superior bargaining power at the beginning of the contractual basis?
Overwhelmingly so.
Okay.
Somebody said, Mr. Norwood suggested that, tenants can just get 2 or 3 year leases. In my experience, I have never seen a tenant in over 40 years of practice. Now remember, my clients are at the lower end, but I have never seen a tenant with a multi-year lease.
Quick follow-up. So you're saying that they wouldn't know enough to contractually do this on their own at the beginning, or would they?
Or would the landlord has no interest in giving one?
Once you say I want 90 days, he's going to move on.
Yeah, especially because remember that if you have a 2 or 3 year lease, you're locking in the rent. And we both know, if from a landlord's point of view, I'm not sure that's the best idea in the world given this market, or most of the market.
Thanks.
Any other questions? Seeing none, thank you very much, and thank you for helping the constituents I've sent your way.
And I will continue to do so.
Thank you.
As long as there's a breath left in this old body. Thank you.
Thank you. Nick Norman?
Thank you very much for the opportunity to speak. I do have some written testimony that I'll pass around. My name is Nick Norman. I'm the Government Affairs Chair for the Apartment Association of New Hampshire. I lead the landlords of New Hampshire on new law that affects landlord-tenant issues as the Director of Legislative Affairs. Some of you know me from other committees. I have a membership and a subscribership of several thousand landlords across the state. I'm a member of many different landlord associations. And I've been a landlord for something like 35 years. So I'm very experienced in these issues. And I would, as we finish my testimony, I would really welcome questions. So we feel that this bill is detrimental to the intent of the bill. It does several things that we feel would worsen the affordability issue that we have in the state. And we recognize there is an affordability issue. And we would like the legislature to help solve it, and we're on board with solving that issue. But I think that you got to realize, and maybe you do, that the essential problem that we have in the state that bills like this are reacting to is that there is overwhelmingly more demand than there is supply for housing. If we had more supply of housing, this would not be an issue. Many things would not be an issue. So where we need to focus our attention is on creating more supply of housing. This bill does not do anything to create more supply. So that's the first point. So it will depress sales, especially owner occupants. It'll put more incentives on increasing rent, so I'll go into these points in a little bit more detail. Extending notices on the various bills that are around the legislature for the past year or two and this year actually drive up the rents and puts tenants often in the situation in our market. I've seen it myself when we rent apartments. The tenants are paying double rent just to get something secured so that they know they have it and it's not available yet. They'll pay another month's rent while they're paying the rent where they're at just to get something, or maybe it's 15 days or whatever, but there's definitely a problem. So that increases, of course, tenants' expense. It delays repairs. It doesn't cure the issue. It creates significant delays in protecting the quiet enjoyment of the property. If there's hazardous repairs that need to be done, it delays getting those done. It creates a greater uncertainty about managing and running the apartment. And in the investment world, when you have an investment and there's a greater uncertainty, then that detracts from the value of the investment. It adds another barrier to being a property manager and a landlord and an investor. Anytime you add more barriers to the process of owning and managing property, then you're disincentivizing property owners from being property owners. And we need people to be property owners. In particular, what's been happening over the past few years is legislation has come out like this, and particularly the eviction moratoriums, that are driving small mom and pop landlords out of the business. I'm hearing it a lot. These people are like, I'm done. Like, it's too much. Everything's coming at me and restricting me, reducing my income. It's making it harder to be a landlord. I'm done, I'm out. They sell their property. That's a shame, because what happens is that's another property of affordable housing that's now gone. And what happens, and I think it was referenced already, you'll see not another small mom and pop person buy that. You'll see an experienced investor that has more units, more experience, more financial backing. They come in, and what do? You know what they do. They take and renovate the property. They make it 50%, twice as much in rents, because now it's a luxury apartment, or it's just a renovated apartment that's more expensive. And then the rents go up, that rent goes up. Those number of units of affordable housing are off the market. We lost them. So I think that's a big issue, and bills like this just exacerbate that. Note that all of the New England states and most of the country has 30 days notice. overwhelmingly. So, few points. A common sale of a small multifamily, which is affordable housing usually, is a buyer wants to occupy. So if we're putting in delays on FHA financing, which is common for owner occupants, that's going to cause a problem in the sale. This is going to put a dampening effect on sales, we think. Someone was talking about notices how long it takes. I think it was Senator French. A landlord wrote to me and said, I gave a tenant 90-day notice. They stopped paying at 60 days. Now they're looking at 120 days before they're out. They just did a filing with the court to do some tricks in the whole eviction process, and now they're looking at 150 days. It's too much. It is also just restricting individual property owners' rights, waiting to close 90 days. Well, I guess I said that, the dampening effect. I said that. It doesn't cure the issue. There is a problem in the real estate world of investing of evicting very troublesome tenants. It can be really hard to evict a very troublesome tenant, a tenant that's disturbing the other tenants in the building, causing perhaps threat to the other building, causing significant damage. And what's really hard is evicting someone that's a drug dealer. During the pandemic, I had a drug dealer in my building. We couldn't get him out because of all the, eviction moratoriums, and you have to prove those kind of things in court. So it can be very difficult. Sometimes a landlord chooses to say, well, I am going to renovate my apartment because in the end it's better for me. I spend money, it'll get me more rent over the span of maybe 2, 3, or 4 payback. I'll have my money back. I'll get the drug dealer out or the problem tenant out. So if you're delaying all this additional time to make it better for the other tenants in the building, we think that that's not good for the other tenants either. We talk about additional burdens. Here's something that I hope that people will start to understand. If tenants are giving a 30-day notice to vacate, that's our common law. That's our law. And a landlord has to give a longer notice, 45 days, 60 days, 90 days. Work that through, right? So the tenant is given 90 days. They're out looking for something. What is available 90 days from now? Anything? The tenants are giving 30 days notice. So here's someone looking for something 90 days out, 60 days out, right? By and large, they are not going to find it because it's not even available. The tenant living in that unit hasn't given notice to the landlord. So now the landlord is getting all these people looking for apartments further out. That is creating a false demand. You see the problem, supply and demand? Now we've increased the demand, and then what's going to happen? Again, the rents are going to rise. There's got to be a balance, So you'll see that. I understand that there's a lot of bills that are well-intentioned, but I'm uncannily finding myself protecting tenants now from bills that we feel will exacerbate the housing affordability problem. Okay, I'm ready for questions,
Thank you.
and I encourage you to read the whole thing.
Senator Susie.
Thank you. Thank you, Mr. Norman. I just have a couple, if I may.
Great,
One
thank
was
you.
regarding the amendment that Attorney Berry presented. I wondered if you had had an opportunity to see that and if that would help to allay some of the concerns you have
So-
specifically about repair.
Yeah, It sounds like that would address some of the concerns about repairs
Okay.
of significant or hazardous things, things of that nature. I'm not sure how we prove what category we're in. It's always an issue for a landlord to use a function of the law where it's like, I'm before a judge. How do I prove this situation? But despite that, we feel that the bill is quite destructive to the affordable housing situation. So, I mean, there's a lot of other issues, but I do believe that that would help.
Okay.
And I haven't looked at it.
Okay. Appreciate that. And if I may ask just one other.
Please.
If you would just comment on the situation that Attorney Barry described, where you have an elderly person who's lived in the same apartment, who's a model tenant, who receives this kind of a 30-day notice, who may have lived in that apartment for 30 years, why would we not want to extend a little bit more time for something that disruptive to someone in that state?
Yeah. So I'll tell you what I observe, because I talk to many landlords, and I've been a landlord myself. Most landlords are too kind, bluntly. They're too kind. So someone like that comes to me and says, oh, well, you know, take the time you need. I don't want to disrupt your life. Tell me what works for you. I have a tenant in my properties that's been there for approximately 30 to 35 years. He's not a problem. But you know what he is? He's the only smoker in my entire portfolio. We stopped allowing smoking, but we let him, you know, he said, don't say I can't smoke. I don't know what I'd do. I said, fine, Kevin. You know, so tenants can come to the landlord and say, this is what I need. There's nothing to stop a tenant from coming to a landlord and saying, this is what I need. And by and large, you'll find the landlord will do that because it's good for business.
Thank you, Mr. Norman.
Senator Bradley?
Good morning. So if we were to adopt the amendment that was given to us by Mr. Berry, and instead of 90 days, it were 60 days, what would your view be then?
If you were reducing the whole thing from 90 to 60?
Yes.
60 is much more tolerable, less of a disruption in business. It still has the same kind of effects that I described, because you're creating this imbalance with 30 days and 60 days, and it's going to, you know, increase the demand, and so it still has problems, but it's certainly better.
Okay.
I'm sure that we would still feel like we have to oppose it because it's worsening the housing affordability. I really think we need to put a lot of effort on creating more housing, and anytime you put a barrier, it's worse for housing.
Anyone else?
Thank you for the question.
Seeing none, thank you very much.
Thank you very much, and please call me anytime to talk about real estate. You got my contact info.
Great, thank you. Jane?
Good morning.
Good morning.
Thank you for having me, Senators. My name's Jane Haig. I'm a resident of Manchester, and I'm representing myself, although I also work with other concerned citizens loosely allied as the Manchester Housing Alliance. And our goal is to make sure that there's safe, clean, and affordable housing for all the residents in Manchester, particularly. I'm here to support SB 217 to expand the notice period in the midst of a devastating housing crisis in New Hampshire. Although, as Mr. Berry said, there's hardly been any times in our New Hampshire history when we haven't been in some kind of lack of housing, especially affordable housing. But in particular, this last couple of years has severely tilted the playing field in favor of landlords. with housing prices and values for multifamily buildings increasing dramatically, there's every incentive for landlords to either fix up a building and sell it or sell it to another buyer. And they stand to make a lot of money. And I've been reading about other localities. In particular, I read about Tucson, where really market manipulators are going in and drastically raising the rents, and then leveraging their portfolio and buying multiple buildings. So there's, in some ways, nothing wrong with a landlord wanting to fix up his properties. In fact, I think we might all agree that it would be a good thing if a lot of the deficient housing, the older housing in Manchester, was renovated to be cleaner, safer. A lot of it needs renovating. However, the problem is, as we've heard, that there's nowhere for tenants to move, especially in this current market. Now, ideally, we would also be building new, clean, safe, and affordable housing in New Hampshire. And hopefully that might be more energy efficient net zero housing, and then in which case some of our less wealthy tenants would have a wonderful place to live that they could look forward to staying in for a number of years, and then their current housing would be renovated. However, at the moment, there is no vacancy. There are no vacancies, and it's with rents rising dramatically. I think it's only fair to level the playing field by giving tenants 90 days notice if a landlord seeks to monetize his property and fix it up in order to get higher rents. That's all I have to say. Thank you.
Thank you. Any questions? Seeing none, thank you very much for coming today. Alyssa, did you want to speak to this one?
Good morning again, Mr. Chairman. My name is Alyssa Margolin. I serve as Director of Housing Action New Hampshire. We're a statewide coalition of 80 organizations united around affordable housing policy and ending homelessness in New Hampshire. We are in support of SB 217, and I did confer with Mr. Barry from New Hampshire Legal Assistance, and we're very open to reviewing an amendment that includes the one offered by Mr. Barry and 60 days as articulated by Senator Bradley. I just want to share some data points with you. 29% of Granite Staters rent their home. I think that's more than most of us think are renters, and that home is obviously a place they want to be near their work, and they want their children to be able to access their school. Relocation is a major family event. That's why many of our members are held to a federal standard around relocation through the Federal Relocation Act, because they are often finance their affordable housing properties with federal resources and have been in compliance with a 90-day notice around renovation or purchase and sale since 1970, and they're able to operate in that environment. Another new set of data out from the Joint Center for Housing Studies at Harvard just this week. I'll give you the bad news and the good news. The bad news is that New Hampshire lost the most affordable units than any other New England state. We lost between 30 and 39% of our affordable units in the last 5 years. The good news is that we have been dealing with eviction prevention better than other New England states. So we're in the top states for addressing the eviction prevention programs, particularly during the COVID pandemic. And so I want to thank all of you for working with us to make sure that we could address and avoid that eviction tsunami that many people were predicting in New Hampshire. So yeah, we view this proposal as good policy, particularly given the crisis and urge your support. Thank you. Happy to take any questions.
Thank you. Any questions? Seeing none, thank you very much. So, Hyatt? Hyatt? Yeah.
Hi, my name is Sophia Hyatt, and I'm an attorney at New Hampshire Legal Assistance. Unlike Elliot, I've only been there for about 7 months. In those 7 months, I've had over 5 renovation cases for renovation sale evictions, and I want to talk about some of them. One, recently I had a client let me know that 3 days after he moved out of his property, his landlord had posted it on Craigslist with photos, and the only thing that had changed was that he painted the property. That's not what the law is supposed to allow landlords to do here. You know, I know Elliot talked about that it's not just about bad actors, but I do think it's important for us to recognize that those exist. And the fact is that we're not saying that people shouldn't be able to renovate their buildings. We're not saying people shouldn't be able to sell them. I've never heard of a renovation or a sale of a property where you don't have to buy materials or hire a contractor or a realtor, and that takes time. So realistically, it's not an undue burden on a landlord to say, you know, give 90 days notice or 60 days notice, because these things take time, and if you're planning a legitimate renovation or a legitimate sale, you should be able to have that time because, you know, those things, that process takes planning. And so by changing this, we would disincentivize these bad actors from manipulating the law and circumventing the legal eviction process, which we obviously don't want happening. But it would still allow the landlords who want to do this in a reasonable way to go ahead and do so. The other thing is just that, you know, some of the things that have been said earlier about drug use, you know, that's not relevant to that. There's other ways you can evict for things like that, and you only have to give 30 days notice for a behavior eviction. Or if someone, you know, let's say there's a 90-day notice given if this bill were to pass. Someone talked about, well, if the tenant stops paying rent, what do? Then you file an eviction for non-payment of rent, and that only requires a 7-day notice. So this isn't removing any of those options or pathways for landlords to continue to exercise their right to evict for other things, which are legitimate. This is just trying to bridge the gap and provide the balance that's necessary for these tenants who don't always know what their rights are. A lot of the times the clients will call us and say, well, I'm planning to move out when my eviction notice expires. And we say, you don't have to do that. A lot of people who don't get legal assistance don't realize that, and they move out anyway. So they're not actually even staying those full 30 days. So we just want people to have, you know, the people who don't get legal advice, who might move out before the eviction notice expires, at least that would provide them with more time. And as Elliot said earlier, you don't have to stay the full 90 days. You know, someone can move out as soon as they find new housing. And I think another thing that's very important to address is, you know, the conversation about, well, this is going to incentivize big companies coming in and buying properties and upping rents. That's already happening. That's what these evictions, these 5 evictions that I've worked on in these short 7 months, that's exactly what's happening in these cases. A lot of the times, it's a big company already doing this. So I think that it actually would provide protections for smaller landlords who legitimately want to renovate their property so that they can have their tenant out, not, you know, if they have 90 days and the tenant finds a new place, maybe they don't have to go through the court process, and that actually is more efficient for people. Just thinking for a second. Yeah, that's all I have to say, and I'm happy to answer any questions.
Thank you.
Thank you.
Any questions? None. Thank you. David? David Klein? Please step out. David?
Yes. Sorry, I was outside listening on YouTube.
No, that's fine. I don't blame you.
There is a shortage of seating as there is housing.
Yeah.
My name is David Klein. If I repeat anyone's argument, I apologize because I didn't hear everything on the YouTube outside. I am a landlord. I'm opposed to the bill as written. I have not seen Elliot Berry's latest amendment, so I'm not really sure what's in it at all. I know it's something to do with renovations. I don't want to repeat arguments that were previously made, but I do want to point out just a couple of things. One of the things with this 90-day period is that, as the previous speakers talked about, if you're going to renovate, you're going to hire contractors. Well, the problem is these contractors are so busy right now, getting a plumber to do anything is almost impossible. Good renovations are going to require licensed personnel, the electricians, the plumbers, the gas fitters. And if we have such a long period of time, these guys are going to go to other places where they can make their money right away. What that does is then it takes that unit you want to renovate, and it's going to be off the market longer. And the last thing we need in this state right now is more units that can be put on the market, taken off the market. So it will affect that in that way if it's that long. Whether or not you have to evict someone at the end of the 90-day period is totally voluntary on the part of the person who got the eviction notice. They still have the right to stay there and take it through the court process. So saying they're going to be out at the end of 90 days is totally speculative. Some people move out, as was testified. Some people fight you and delay it. I had one tenant who took it up to the Supreme Court, and just because of the vacation schedules and all of that, it took 6 months to get her out. And I have very, very good grounds and won at the district court. But the judge was on vacation. They didn't look at her appellant notice, and when they did, they finally turned it down, but it still took more than 6 months. I'm going to reiterate that when you take it out of balance, meaning one side's at 90 days, one side's at 30, those apartments that are going to come on the market for people to rent are going to come on and they disappear. I have 8 very small buildings, mostly 4 units. Generally, the one-bedroom apartments rent within 4 days. 10 days, everything we have is rented, so that what comes on disappears very quickly. You're going to have people looking long-term. And yes, some of them may be tenants at will, but also a number of them are going to be lessees, and just sale of the building or renovations in and of itself is not grounds to terminate a lease. So a lot of these people are going to want to protect themselves, not have that they broke the lease, even though they got notice, and ride it out to the end of the lease period. So they're going to be looking at 90 days. Well, they're not going to find anything because they're looking for something 90 days out when things aren't coming on the market until 30 days before the termination of that lease. And it's going to put more burden on them, and it's not going to do them any good. There was some discussion about 60 days. I would think 60 days would make more sense given all the factors than 90. Yes, some of the long-term tenants, I know I didn't see who, I could only hear it on YouTube, was talking about somebody who's been in an apartment for a long term. I have one of those tenants. He was there when I bought the building 12 years before I bought it. He's been there for another 17. We're going to give him a minimum of 60 days. And I don't think that's an unfair amount, that type of long-term thing. But 90 is just too long. I appreciate you letting me speak, and I'm certain we'd take any questions should anyone have some.
Thank you very much. Questions?
Thank you very much.
Thank you. Jessica?
Hello.
Good morning.
My name is Jessica Margerson. I'm a volunteer with Granite State Organizing Project. And since September, I've been running an eviction clinic we now term the tenant clinic, and helping multiple tenants that have gone through these evictions. Since the beginning of the pandemic, we struggled to turn around and help tenants understand what was going on, and we watched the evictions changed. I watched evictions stop with the moratorium, and some landlords started getting inventive. Tenants started getting evicted for multiple different reasons, and then this one started growing, the renovation eviction and good cause. I watched multiple tenants that had been long-term tenants in their units, great tenants that built up our cities, just be wiped out. Tenants came to my clinic saying, I look outside and the building to my left and the building to my right is sold. Multiple tenants have said that. The amount of tenants that have come through with these is amazing. Multiple tenants have had to go through court just to try and get more time for their eviction. This will help free up the court a lot because tenants are having to go and beg for a discretionary stay of up to 90 days. They're also having to fight their eviction because they don't know about asking for the scope of repairs. And multiple tenants don't have time to go back later after the eviction and say, hey, was this really necessary, and do anything about it. In 30 days, New Hampshire tenants are expected to keep working, keep getting kids to school, look for an apartment during historically low tenancy rates and skyrocketing rents while navigating the application process for rental assistance with the New Hampshire ERAP to be able to either stay or relocate to another unit while also learning their rights to decide whether they legally have to move or not. So let's break that down. We got the New Hampshire ERAP. Currently, right now, there is such a demand for this due to the number of renovation evictions and buildings sold that they have a 7 to 8 week wait list once evicted in a shelter to even get to a hotel. They wait months in a hotel while trying to find an apartment. This encompasses people with Section 8 vouchers, those with plenty of money. I've met tenants with multiple amounts of money to be able to pay, but yet there is a lack of demand, as Nick Norman stated, a lack of supply. We have a huge demand, huge lack of supply. This has led to tenants being more vulnerable to homelessness due to the strain on our services to help many of them. They have flooded the system, creating such horrible situations. As I stated, 8 to 10 weeks to get through, 7 to 8 weeks to get into a hotel while waiting in the shelter. It takes 8 to 10 weeks just to get through the application process to know what you're going to be qualified for. There's multiple reasons to list. While 90 days is a very good idea to institute and not 60, 90 days is needed. I can speak on my own even. I had a renovation eviction while helping multiple people. My rent first went up $500 a month, and then my landlord decided to renovate and sell the building. So while helping others, I had to struggle through this. I instantly applied for the NHERAP program and let my landlord know that he could get 3 months of rent with this program. I created a deal with him that if I could get through the program and the funds were able to go to him, he would give me those 90 days. I was able to find an apartment in those 90 days and move successfully without having to go to court and beg for a discretionary stay or fight it. That is how it can help free up the system. It gives the tenants 90 days to get through the process of their application, start putting out applications. Every apartment out there receives 500 to 1,200 inquiries. I have tenants calling me crying, and I just tell them to stay the course. Keep calling those apartments. Keep calling them. By the end, hopefully something will work out. Left foot, right foot, keep going. Something will work out. They don't all work out because there's not enough supply out there. So I ask that this be put through and Elliott's amendment taken consideration. Thank you.
Thank you. Any questions? Seeing none, thank you very much.
Thank you.
Brandon? Brandon LeMay? Marcus? Yeah.
Good morning.
Good morning.
Good morning. Thank you for having me today. For the record, my name is Brandon LeMay. I'm representing Rights and Democracy. We are a grassroots organization of members across New Hampshire to effect change at the legislative level, the policy level, and also during elections too. And I'm here speaking in favor of Senate Bill 217. And I just want to throw out a scenario to this committee today. I want you to imagine that you come home from work today and you get a call from your landlord that says you have 30 days to get out of this house right now. I just want you to imagine that scenario. And I say that because this is a scenario that I hear all the time. And I want this committee to know that I have been that person too. Back in 2016, got home from a day of work. My landlord let us know that she doesn't want to be a landlord anymore. She wants to move to Florida and retire. And she wants to sell the house, and she doesn't want to show it with tenants inside of it because she thought it'd be easier to sell the house. The pure terror that came over me of trying to find a place to live within 30 days overcame me. I couldn't sleep well, couldn't eat well. 30 days was not enough time. And keep in mind, this was 5-6 years ago, back when vacancy rates were actually a little bit higher than they are today. So what we ended up doing was we thankfully somehow found a place with like 10 days left to go. It was the only place that would actually take us. And we said, hey, it's a roof. We can afford the rent. And I guess we'll do it. And we had to overlook a lot of problems. This house wasn't properly winterized. It was an old home on the border of Manchester and Bedford. And It cost us about $200 a month each for heating because it was so inadequately insulated. And we were stuck in that place for a bit. We couldn't find another apartment that was suitable for us. And I was reading a book called Evicted by Matthew Desmond. He's a sociologist. And he followed around a bunch of families in Milwaukee after they got evicted. And there was a particular quote from his book that really lines up to what we have seen in Manchester. And this is 25% of all people who have been involuntarily removed or evicted from their last places found troubles with future rentals. Or sorry, 25% more of them have trouble with future rentals when they're forced out of their current place. So basically, I think that 90 days is much more reasonable. I don't think anybody in this room could find a new place to live in 30 days. And I think, as Elliot Berry has said, that the landlords have a lot more power in this dynamic. I do understand that, we don't want to put undue burden on a business, but I think we can all agree that housing is something that we fundamentally need to function. I can't be a good worker if I couldn't take a shower before this hearing, if I couldn't wash my clothes in the washer and dryer. I don't think you'd take me too seriously if I wasn't looking too professional here right now. So I just want to say that those 90 days would have made me much more able to find a more suitable place, and I probably wouldn't have had to break my lease after that, and I would have found more stable housing. And finally, I could throw a lot of anecdotes at you, but I do want to just bring up a story of a man named William O'Connor in Manchester. He's a member of ours, and he was hit with a 30-day notice. He was living month to month in an apartment where the ceiling, was falling down on him. And he is a single father of 3, and this also caused him to not be able to sleep properly. He was scrambling and scrambling and scrambling. He applied to over 50 places before he actually found one that could take his housing choice voucher. And what he had to do in that time was he had to go to the court to get an injunction and to get a stay on this eviction, which then caused the landlord to have to then also show up to court while he was still duly trying to find a new place. So I just think that these 90 days would actually lead to fewer evictions. 90 days seems unreasonable to me. So I think 90 days just seems, I think it's fair. So, and that's it. Thank you very much, and I'll open up to any questions.
Thank you. Any questions? Seeing none, thank you very much.
Okay, thank you so much.
And Jack Cohen is opposed and not wishing to speak. Anyone else here wishing to speak on Senate Bill 217? Senator, would you like to speak again? Come right up.
Thank you, Chairman, and I'll be brief because I know you're behind on your schedule, but I just wanted to take the chance to come up after you've heard all this testimony and sort of recenter the conversation. I'm a commercial real estate lawyer. That's part of my practice. I draft purchase and sales. I do closings. We consider the things that need to happen before we would close on a real estate transaction, and those can be accounted for. There are always things that take a little longer than you think. There are other things that take shorter. And so I know that there's commercial considerations here, and I think those can be worked around. But on the other hand, I'm also a housing advocate. I've been working on this for over a dozen years now, and I agree with everyone who has said the problem is long-term supply. Senator Bradley and I are working together on SB 400, a bill that I helped draft out of the governor's office that targets long-term supply. That is really the problem. We all agree on that. And yet, we're here in this situation hearing that someone who's worked at New Hampshire Legal Assistance for 7 months has handled 5 of these cases. So while we are lucky to have small landlords in New Hampshire, and we know they're kind, and we've heard their testimony today, some of these new buyers, they don't know those tenants. They don't have those relationships, and so they may need the help of a little bit of legal protection. So again, there will always be situations that take longer than we think. Those exist today. They won't be changed, by adding a little bit more notice, whereas someone being able to stay in their home, their life could be changed, by having to give a little bit more notice. And again, it could also avoid some of these court situations. Lastly, we've heard some proposals that I think could lead to some compromise here today. And so I just want the committee to know I'm going to reach out to the parties that have been here today. I'll try to work with them on that. And maybe, Senator Bradley, we can work on an amendment that I can bring back to the committee.
Senator, I do have a question if you've got a minute.
Yes, sir.
So this affects only to perform repairs, renovations, or to sell the property. Does it affect any other 30-day notice for other reasons?
No. It merely wants to extend the notice period in these very limited circumstances that are complete and substantial renovation of the property or sale.
But other reasons, it does not extend it past 30 days.
That's correct. So for example, a nuisance tenant, which has been brought up, is still under the 30-day notice or otherwise under law. Hazardous situations where the tenant really should be moved out more quickly, that's what the amendment is here, to make sure that's protected. But it is not.
Non-payment of rent.
Non-payment of rent was addressed actually by a bill we worked together on last year that passed, SB 126. So non-payment stayed at 7 days notice in arrears, but the tenant now has up to the date of the eviction hearing to make overdue payments in order to stay in their home.
Right, okay.
Okay?
Thank you.
All
Anyone
right.
else?
Anyone else?
Nope, we're set. Thank you very much.
Thank you, everyone.
I'm going to close this hearing on Senate Bill 217. Now, my favorite bill. My favorite. Yeah. Take your time. Enjoy the moment.
The Honorable Harold French. Good senators here to testify. Go ahead, Senator.
Thank you, Mr. Chair. Good morning to all of you. We'll get through this real fast, I'm sure. My name is Harold French. I'm Senator from District 7. I'm here to introduce today Senate Bill 249. When I brought forward Senate Bill 249, as with all legislation I bring forward, I looked at it as the start of a conversation we should have. Since the initial bill appeared to be a bit problematic, to say the least, with several communities and some residents, I have worked to address their issues in the new and improved version you have before you today. Thanks to my good friend from the local Conway paper, I was able to get a sense of what the residents found to be most disturbing, which apparently was me. The legislation states that a municipality cannot ban short-term rentals. In various communities in my district, and I know in Senator Bradley's district as well, towns are currently suing their own property owners, and property owners are suing towns over that homeowner's ability to rent their property on a short-term basis. Recently, a judge presiding over several of these court cases pleaded with the state legislature to step in and set up some statutory perimeters for both property owners and municipalities. Therefore, this bill. The headline of the Union Leader article reads, "Judge who will weigh in on Conway's regulation of short-term rentals would like to see legislation set a statewide policy." And that's what we're trying to do here today. Senate Bill 249 is modeled on the accessory dwelling unit bill this legislature passed several years ago. In that bill, the legislature mandated that towns had to allow a property owner the ability to construct an accessory dwelling unit within their home. However, the bill also granted towns a great deal of leeway on how they would regulate these ADUs. Same idea is applied to Senate Bill 249. Towns would be prohibited from using its zoning power to eliminate the use of a single or two-family structure from being used as a short-term rental. However, towns would retain all existing authorities to regulate those rental properties. Towns could regulate parking, noise, sanitation, health, and safety in the same manner they can currently do so. They simply cannot ban short-term rentals. Additionally, Senate Bill 249 grants municipalities two new rights. First, they can mandate all short-term rentals register with the town and charge a fee. Currently, state statute requires long-term rentals to register with the towns, but does not grant similar authority on short-term rentals. I basically copied the statutory language on long-term rentals and made it applicable to short-term rentals. And if a rental property becomes a problem, then Senate Bill 249 grants towns the ability to rescind the registration. Senate Bill 249 also grants towns the right to inspect a single and two-family home, something which is currently expressly prohibited in statute. I am a big supporter of private property rights, and granting the government the right to enter a home is not something I particularly like. However, Senate Bill 249 even grants towns the ability to charge a fee for this inspection. However, this bill is designed to balance the rights of private property owners with the needs of a town to regulate for health and safety of residents and visitors. Thank you, Mr. Chair.
Thank you. I'm going to start the questions, then we'll go to Senator Bradley. Were the towns, such as yours or Senator Bradley's, were they giving any compensation for taking property rights from the owners?
Would they be?
Were they? When you set it up in Conway and Wolfboro and some of these towns, they were saying you couldn't rent your property for short-term rental. Were they offering anything back as compensation? I'm asking that because, to me, it would be a violation of the Fifth Amendment, the taking clause. You have to, if you take someone's rights, like a property right, you have to compensate them. Were they in the past offering any compensation?
Not that I heard of. Thank you.
Thank you, Senator. Senator Bradley?
Yeah, thank you very much. This is more a procedural question. Aaron, does the public have copies of this amendment? And if not, I think it would be really good, since Senator French has made some significant changes, to make sure that everybody has it. Thank you.
Thank you, sir.
Thank you, Senator French. David Kavanaugh? Okay, go to number 2.
Chris Vashon? Is Chris here? Vashon. Andrew Hosmer. Hey, there you are.
Good morning.
Morning.
Perhaps Scott Myers, the city manager from the city of Laconia, can join me.
Come right in.
Thank you, Mr. Chair.
Welcome, Senator.
It's nice to be here. For the record, Andrew Hosmer, Mayor of the city of Laconia. And I am joined today by our city manager, Scott Myers, who we sign in, as much as it pains me, Senator French, to oppose something that you sponsored. We sign in opposition to this.
I saw that.
You don't miss much. I'm just going through the amendment right now, but I'd like to have perhaps Mr. Myers just talk about what prompted the city of Laconia to put some guardrails in place when it came to short-term rentals, and just give you a little background, and maybe I can finish the amendment. Thank you.
Thank you, Mr. Chair and Senators. So the city of Laconia did adopt a short-term rental ordinance 2 years ago at this point, and we have close to 200 properties registered, and it's worked very well. For the record, we've not had any court cases. We aren't relying on any threats or any penalties. It's worked well from all takers, from what we hear. Without having the opportunity to hear the amendment that you just presented, Senator French, our concerns were that the bill originally did not go far enough, and I would have to read through what you offered up. But things we have in the Laconia ordinance, and I'll just leave you copies, I'm not going to read it verbatim, and I also have the application packet here, pretty simple. We were charging a $250 fee for a 2-year registration, so basically $125 a year, which is probably in most cases less than the cost of one night's rental. Right. We allow it by right in 2 zones where we think it's appropriate, and we allow it through the Zoning Board of Adjustment by special exception in other properties. We've made exemptions for an owner-occupied property in any zone to be able to offer short-term rentals if the owner can satisfy they've lived in the property for 150 days out of the year. We went less than half the year in case somebody was a snowbird and needed to declare residency in a southern state. So we didn't try to split the year exactly in half, so 150 days. We've also have opportunities if someone has shown that they've been renting a property and can document that for a period of 5 years or greater. Then in our view was, if it hasn't landed on our radar and it hasn't been raised to that level, obviously they're handling it right and the neighbors don't have concerns that we've been made aware of. What we also do that it was not in the original language of Senate Bill 249 is we do a basic life safety inspection, not a full-blown, fire code, but are there a working smoke detector, CO2 detector? Is there a fire extinguisher that's visible? Do all the windows and doors open? And if you're using the basement for bedrooms, do they have appropriate methods of egress? We require all the parking to be on site so that parking isn't spilled over into the street. We also use, through our building ordinance, a simple formula of how many people can occupy the building for overnight, not during the day when you might have friends over for a cookout, but overnight sleeping. And I'll give you an example. In a 1,400 square foot property, the first 400 square feet allows up to 4 people, and each additional 200 square feet allows for an additional 1 person. So a 1,400 square foot house, which is not big, would allow for 9 people. This would kind of help, stop the problem of what you're hearing about the party houses and 20 people are all landing and going through it. So we would love the opportunity to work with you, Senator French, any members of the committee, to just get a little bit more. I loved how you paralleled this to the ADUs because that's what I was thinking exactly. They need to be allowed, but the community has the opportunity to put some framework around what we believe are some simple common sense protections for people who are coming to Laconia and staying on one of these properties, but also for the neighborhoods. And I can stop there and take any questions now or let Mayor Hosmer add any thoughts as well.
Sure. I have had a chance to take a look at the amendment. Senator French, it is, from my perspective, better than the first draft, which is great to see. I'd still like a little more time to study it. But I want to let you know, too, the city wasn't looking for something to regulate. We weren't looking for issues to get involved in. Really, this was brought to our attention because of some properties within the city that, for instance, a 3-bedroom house on a lake in a quiet neighborhood with senior citizens on one side turned into an Airbnb and turned into people. In this 3-bedroom, there were 22 people, many of them in the basement. It destroyed the quality of life for people who had their lifetime earnings in their retirement home. And they had owned that property before the Airbnb owners came in, or the house had been used for Airbnb. It was a significant impact on these folks. And we needed a little bit of leverage as the city to be able to, one, still allow the property to potentially be used as an Airbnb, but also put guardrails in place. I will also say in another neighborhood on the lakefront as well, more senior citizens were in a neighborhood where a house was purchased for Airbnb and the trash was taken out when, typically on a Sunday afternoon or Sunday evening. Unfortunately, trash pickup wasn't until midweek. So you had the trash sitting out there, which again impacts the quality of life, impacts property values, and there are also some safety issues that are associated when you have too many people in a house, quite frankly. So I'm glad to see you've included that there can be some life safety inspections here. I think that's critically important. And I also want to let you know that one of the balances we've tried to do in the city is how do we handle our housing stock, which we know we don't have enough of in the city. And if we have some neighborhoods that are become predominantly or trending to go predominantly Airbnb, what happens to the neighborhoods that we'd like to see created in the city or maintained, which is a place that would be people's primary home, that our firefighters, our police officers, our teachers who work in the city or work in the area have a place to live and raise a family. You know, we're losing some of that stock for the Airbnb stock, and that's one of the reasons that policy reasons that we waded into this, and we've done so cautiously and hopefully pragmatically in the city of Laconia. That's all I have as far as my input, and it's a pleasure to be here. Thank you.
Well, it sounds like the city of Laconia is once again leading the way in innovative living. And thank you for your efforts, Mr. Mayor and Mr. Manager. Any questions? Yes, Mr. Senator Gannon.
Thank you, Senator French. Just a quick question. I appreciate the need for regulations, common sense ones. 20 people in the cottage next door to me doesn't sound too nice. What I was concerned with your testimony was sort of towards the beginning. So you were talking lakefront. I happen to have a home on a lake, and I happen to have a cottage on a couple acres next door, which someday I hope to fix up and rent out. So I'm concerned in your town, what if you were saying zones? If I'm in a certain zone, am I going to be totally banned from renting? You were talking about zones. That concerned me if I fell into the wrong zone.
We have two zones. Thank you for the question. We have two zones that are allowed by right, which we amended our zoning regulations because prior to that it was occurring, but it wasn't allowed by zoning in anywhere in the city at that point. So we identified two zones in particular where it's by right and you go through the application process. And then the other one would be going before the ZBA for a special exception as was outlined before as well. I'm not aware of any other industry where zoning doesn't come into play. I mean, we wouldn't be allowing motels, hotels to be building in residential neighborhoods. So that's why we thought that we would allow it by right in certain areas where it was either a transition zone or already, had some of those resort type of amenities to begin with, and then allow an extra hurdle, if you will, to have it in other places. But again, in all situations, an owner-occupied property in any zone is also allowed by right. So under that scenario, what this really prohibits is somebody just buying up housing stock and using it strictly as an Airbnb platform all the time.
Follow up?
Sure.
So in my case, house, cottage, inherited, whatever, I don't live there, but I still see that I have a huge property interest in that place. Would you consider maybe, I can see the problem with people coming and buying up the whole town. Would you consider maybe having an exception for if you own two and under before this would kick in?
We'd be happy to work through the language, and again, just seeing the amendment this morning, we don't ban it. We know there's a need for it. We're trying to make it work for those who want to come and recreate and for those who live there. I didn't want to get too much in our ordinance that I'll leave with you, but we also have something called a seasonal dwelling. So if something was truly a camp and it wasn't heated and winterized, and it's been rented as a summer cottage forever, that's grandfathered as well. So we've tried to, you know, we're not gonna come up with every situation and have an answer for it, but we've tried to be reasonable and listen to our residents.
Thank you.
Senator Bradley.
Yeah, thank you very much. Good to see you both. It sounds to me from your testimony that everything that is in Senator French's amendment, you would not have any objection to, and that your ordinance comports with it, except potentially some question about the ZBA process. Is that correct?
Again, just scanning it, I think the two things that I like that I heard is that it would allow for an inspection now, because the original bill said that a property owner did not have to let you enter, and then only if you were identifying there might be a problem with the housing stock, you could go to court. That seems like an onerous process. The other thing I don't know if it's changed in here is our application says provide the name and a phone number of someone locally who is responsible. The original language in the bill spoke to give us a mailing address for someone who you could legally serve, and that doesn't sound like an expeditious turnaround. If you had a problem with noise or trash on a given day, I would much rather have a phone or an email from someone rather than an address for legal service.
And wouldn't you, if I might, Mr. Chairman, think that that's covered in the registration process, the name, the address, the phone?
Thank you for the question. As I read the language of the original Senate bill, it only said you can require a mailing address for legal service.
Okay.
And our application that we use in Laconia specifically says name and phone number. And again, I think a phone, if we're trying to rectify something quickly, works a lot better than legal service.
Okay. Last question. Your zoning ZBA process, has any applicant for a short-term rental in those two districts that it's not allowed by right been turned down thus far since you've had it?
Thank you for that follow-up. I think we've had one that's been denied on the zones where it's not allowed by right. You either need to show that you've done it for a 5-year period or longer, or that there's a benefit to the greater community more than just to you as a property owner. And to be clear, a property owner saying, well, I can earn income to help pay my mortgage or my taxes, it isn't considered a benefit to the greater community. An example that was given when the council was looking at this was there was a local a theater group that used a property to house actors and actresses for certain productions to help their summer performance schedule, and they used it as an Airbnb rental in the off-theater months for them to help support the theater operations. And that was considered, that would be a greater good for the community in supporting performing arts and local organizations. So that would be an example of something that would receive a favorable viewing on it.
Thank you.
Thank you.
Great. Any other questions? Thank you for what you're doing in Laconia. It's coming along just great.
Thank you. And I will leave the copies of our application in the ordinance.
Sounds good.
Thank you, Senators.
Thank you. Senator Luther, did you want to speak? Come right up. Yeah.
Good morning, Mr. Chairman.
Good morning.
Senators.
Welcome home.
Yeah, thank you. I spent a lot of time in this room. I submitted electronically the testimony that you have before you, and also have given you a hard copy. Now that I've seen the amendment, that does impact a lot of my concerns. But let me just give you a little bit of background.
Yep.
I won't repeat all the testimony, but we have a cottage in Sunapee, New Hampshire, and with short-term renters
abusing all kinds of laws, from sanitation, noise, this sort of thing. And there's one house that's literally across the street from us that sleeps, technically it sleeps 22 people. Okay?
Oh, that's a big house, huh?
That's a big house. On a regular basis, they will, that house will be housing way more than that. We've seen, along with our neighbors, and I've got a neighbor here who's going to be testifying in a little bit, a bus literally stopping in front of, this is a full bus stopping in front of the house and unloading a busload of people that are going to be there for several nights. You can imagine the scene that this causes with all these people. Not a lot of sleep is had by the neighbors. The noise is terrible. There's partying in the streets. Garbage is a real issue. One of the real problems is that with the garbage issue, they will dump garbage into other people's dumpsters and just overload them. The commercial owners in the town, it's a very small town center. And this particular owner of this Airbnb has basically said to the chief of police, who also has sent written testimony, that he doesn't care to follow the law. He's just, I'll do what I want. And actually, the chief of police was assaulted at this house by renters. I don't know if it was this group or another group. So there's not even respect for local law enforcement. It's a real problem. So we've got a real issue. Now, what we've been working on is, I'm part of a working group working with the town manager, who I believe has also sent written testimony, and the chief of police, and my neighbor back here, Ann Bordeaux, and several others, to come up with a working way to deal with these issues. Obviously, when we saw the original version of this, it was like, man, just tie our hands. we can't do anything now.
That was before the conversation started.
Yes, right. So it's always nice to see, and that's right, that's how we make laws, amendments. I do have some questions, though, on the amendment itself, and I'm just obviously reading it now, and really do appreciate the additional language that's been added. But I have a couple questions. In lines 14 to 16, and that's new language, where it says, nothing in this paragraph shall limit a municipality's existing authority to generally regulate parking, noise, safety, health, or sanitation under duly adopted ordinances and regulations authorized under state statute. Okay, that's great. Now, my only problem is when I turn to the back, on page 2 to lines 3 through 5, that is not the same list of issues. It's much shorter. A municipality which has adopted an ordinance requiring registration shall not revoke that registration unless the property has 2 or more proven violations of ordinances impacting, and I see only 2 items, health or safety. That, to me, doesn't work. It's got to be broader than that. We've got challenges that don't necessarily run under that unless there's other RSA language somewhere else that expands on that. The noise, the disturbance, the sanitation, parking, all these other issues are a real problem. And then my other question would be, how does the process work? It seems like what you're saying here is a municipality may adopt an ordinance requiring an owner to get basically to be registered with the town. That's great. What I don't see is what is the mechanism of removal. It does say municipality, that it shall not be revoked unless property has 2 or more proven violations. So I'm assuming that third violation, the town has the privilege. Now, what about that owner wants to come back and resubmit at a later time? There's no language in this that addresses that. And my concern would be, is that just too wide open as far as without having that language? So those are really the two areas of concern that I think the amendment needs some massaging on. And I would certainly support it with those points, but it's certainly a lot better than the original.
Great,
So,
thank you.
Do you have any questions? I'd be happy to entertain them.
Any questions from the panel? Seeing none, thank you very much for taking your time.
Thank you, Mr. Chairman.
I'm going to bring up Bob Quinn to go over the amendment and give his take on it.
I'm going to bring Chris Norwood on as well. Kill two birds with one stone.
That'll be great.
Thank you, Mr. Chair. Again, for the record, my name is Chris Norwood. I'm the 2022 Public Policy Chair for the New Hampshire Association of Realtors. Come in support of this bill and the amendment. SB 249 prevents municipalities from using their zoning authority to ban short-term rentals in single and two-family structured, regardless of how they're occupied, full stop. It's the intent of the legislation, and that's what the language in the bill provides for. It does not take away any municipality's existing authority to regulate, and we've talked about that. You've heard some testimony. And in fact, this adds two new avenues for regulation through registration and inspections. Keep in mind, New Hampshire residents have been renting out their homes for vacation rentals long before Airbnb and VRBO, and clearly those two platforms had made it easier for homeowners to rent out their properties. However, just because something has become more popular and widespread, that should not mean that the government must step in and ban the activity outright, and we feel that this is more appropriate. A response which is ensured that each of these activities is well regulated, again, through those inspections and registrations we aforementioned talked about. We have no doubt that short-term rentals have caused problems, and we're not here claiming that there are not beer cans on front lawns or people being loud, but we would say that those are challenges for both long-term rentals and owner-occupants as well, and I think it's a challenge whereby we say, because of some, to use testimony at a prior hearing, some bad actors, and then that bans private property rights outright in an entire municipality. Municipalities have been granted through state statutes numerous regulatory powers to control activities. This bill does not restrict any of those existing authorities provided under state statutes. And regardless of whether or not SB 249 passes, these issues are not going to go away, and we do not believe they are going to diminish. In fact, previous bans within our state have been the least effective manner to get property owners to behave in a manner that the government desires. So towns that have attempted to outright ban vacation rentals have not experienced a decrease in residences being used for vacation rentals. Portsmouth banned short-term rentals, but there are the same number of dwellings being used as short-term rentals before the ban as there are after the ban. Some folks came up and spoke about Laconia, and in 2019, excuse me, there were 190 residents. Today there are 275. And again, that was a partial ban in certain zones. So again, we just don't think that if we can say we're not going to address this issue head on, outright ban in a community is not going to prevent the problem. And I really don't think the towns want to knock on doors of their neighbors to kick out a family spending vacation or a business person renting for a week while they continue to do work. It's just not, I just don't think it's what the municipalities are looking to do. Again, vacation renters and short-term renters have been here for 100 years, and they're going to be here for 100 years later, and the traveling public in our economy is built upon that. So if bans are so ineffective, why are the realtors caring? is because it disrupts real estate markets, decreases property values, and takes away private property rights. Many home buyers can only afford their properties if they can rent short-term. If that option is not a possibility, then they will no longer seek properties in that community or in our state. Fewer potential buyers inevitably leads to lower home values, and I don't think that we want a patchwork in our state. So I'll now turn it over to Bob Quinn to discuss the amendment.
Good morning. My name is Bob Quinn. I'm the CEO of the New Hampshire Association of Realtors. Before I go into the amendment, I just want to bring up one other point, and that is the impact that short-term rentals have on state revenues. As many of you are aware, last session, this legislature passed House Bill 15, which requires all platforms, Airbnb, VRBO, real estate brokerage, and others, to both collect and remit the rooms and meals tax on behalf of the clients who are renting. While DRA doesn't provide that information publicly, Airbnb does. And between January 1st of 2021 and November 30th of 2021, Airbnb submitted $9.3 million in tax revenue to the state of New Hampshire. Airbnb, we're estimating, probably has about 40%. So the demand is there. The traveling consumer is asking for short-term rentals. The notion that any municipality is just going to be able to put up a wall and say you're not going to come in and you're not going to do this, the market's too strong. And it was, Chris pointed out, short-term rentals pop up anyway. Now, getting directly into the amendment, over the past several weeks, we've tried to amend the bill to accommodate some of the concerns. So I'll go through those quickly with you. First, on line 7, the word towards the end, prohibit, that was originally regulate. I think there was a lot of confusion over that. So if you read the entire sentence, it says that vacation or short-term rentals may not be prohibited. You may not prohibit the use of such structure or building as a vacation or short-term rental based on the structure or buildings, and this is key, classification, use, or occupancy. This is only related to zoning, RSA 674. I think some people were interpreting that word regulate as impacting other statutes, RSA 32 and others, and that was not our intent. So the last sentence is just making that clear, that a community still has the right and their existing authority to regulate parking, noise, safety, health, and sanitation. On the next section, we included that a municipality may establish a reasonable fee to cover the cost of a registration. And again, that's the original language and the amendment. It's sort of copied from the long-term requirement that long-term renters have to register with their town. And the telephone number is required on that. Part 2, this is a result of conversation with the state fire marshal. So right now, town can inspect a property under the original language was 48A14, that stays in, but we added the fire warning device and carbon monoxide, which is again already a requirement under RSA 153. But just to underscore and make it clear that that is a possibility. And again, the municipality may establish a reasonable fee to cover the cost of conducting that inspection. And lastly, in section 3, the municipality may adopt an ordinance requiring a registration it cannot be revoked, that registration, unless there are 2 or more proven violations of ordinances impacting health or safety. If people are more comfortable in adding, as Mr. Luther mentioned, parking, noise, safety, health, and sanitation, we're certainly amenable to that. That was perfectly acceptable. And the last point I'll make, anticipating maybe a question, Senator Bradley and I have had several conversations about the impact of short-term rentals have on the affordability of housing. Obviously, that's a critical issue to our industry and our association. But I think it's important to consider 2 things. One, how property owners are utilizing their private property for rentals. Most are doing it for 1 month out of the year, 3 months, 6 months. In fact, it's pretty consistent when you go across towns. Only about 6% of anyone utilizing a short-term or using a short-term rental, or only about 6% book for more than 9 months out of the year. So if you have Portsmouth as an example, 117 short-term rentals are either advertised on Airbnb or VRBO. Of those 116, 7 were rented out for more than 9 months out of the year. So the notion that if you eliminate short-term rentals, that it's going to resolve your housing affordability crisis, we would question. And you have to flip also the other side of that coin is a lot of people are able to stay in their home or their condo unit because they are able to rent it out. So that's one point. The other thing I'll point out is on housing affordability, the bigger picture. We've heard from previous hearings as well, the lack of crisis in housing. I'll point out that in Carroll County, Department of Housing and Urban Development tracks permits, housing permits, every single year. Carroll County, 50,000 residents. In 2021, there were, in the entire county, 26 multifamily housing units permitted. That's not projects, that's total units of approved. Belknap did a little better. They have 60,000 residents. They approved a total of 60 multifamily units. I was surprised. Look at Grafton County. It was a little shocking. Grafton County approved 0, the entire county. Now, each individual town could say, well, we approved a bunch in 2020. We're waiting for those projects to come online. The point remains, the real issue is on housing affordability is inventory, and we need communities and municipalities, and we're happy we're hearing some municipalities saying they want to get involved in that discussion, and we welcome that. So with that, I have my testimony.
Great, thank you. Senator Bradley, did you have a question?
Yep, couple, thank you. So can we go through the impact on the rooms and meals tax again? I thought I heard you say Airbnb reported 9.3 million remitted to the state and represented 40% of the market.
That's what Airbnb is obviously probably the biggest player in the state. There are others. VRBO is a very large player. Bookings.com, there are a whole host of other smaller ones. In addition, sometimes people will just use a real estate brokerage. They don't go through Airbnb at all. And in other cases, they just rent it out on their own.
And I thought I heard you say that the estimated total impact was?
On a budget, we anticipate it would be about $40 million.
$40 million for a 2-year budget?
That's correct.
About $20 million per year, roughly. Okay.
And we think we're being conservative.
As you know, I have asked the LBA for, estimates on that. Haven't gotten anything yet. DRA doesn't track it, so that's useful information. Second question?
Go right ahead.
So, getting back to the discussion about affordable housing, I was struck by information that I used in my testimony for Senate Bill 400 last week, that the median price of a single-family home in New Hampshire, and I assume this is coming from your organization, is over $400,000 at this point.
That's correct.
Aren't the vast majority of short-term rentals utilizing single-family residences?
I would think that is correct. I will let some folks who are in the industry answer that question.
And maybe others can address this too, but if that's the case, banning short-term rentals, given the value of those homes, is not going to solve the affordable housing issue. Would you agree with that? Because they're different markets.
I would agree with that.
Okay.
And I can add that there was a study recently, the Harvard Center on Housing looked at, and these are bigger cities, most of the studies that take place are happening in New York and Los Angeles, in a zone in those areas where there's short-term rentals, that does decrease, or increase, the strain on median rental prices, but it's 2%. So if you're talking a $1,500 median rental price, maybe an extra $30. But what they also point out is, in that study, that it's kind of a smokescreen, because the real issue is that those zones are not approving additional housing. If they did, this wouldn't be a problem. And I think that's evident here in New Hampshire. And of course, in those cities, most of the stock is condos and apartments.
You worn out?
I'm done.
Okay. Anyone else? Thank you very much.
Thank you.
Thank you.
I'd like to hear from the man who's most mad at me, came all the way down from Conway, The selectman from Conway, did you want to speak?
Most of us in Conway only find you little mad.
A little bad.
I'm not really bad.
Oh, good. If you could just state your name when you get started.
Al Thibodeau, Conway.
Oops.
Copies of our proposed regulations that I want you to take a look at, because I'm going to refer to them here in a minute. In the interest of full disclosure, as you have said, I am a sitting selectman in the town of Conway. However, I am not here representing that board.
Got you.
Okay, I'm here as a private individual. Senator Bradley was given a letter from Chief Solomon. Was that distributed?
Yes, thank you, Carl. Not only the chief's letter, but also one of your colleagues, Mary Seavey, and Mark Hounsell's letter.
Thank you for that, sir. I want to just start off by reading a portion of that letter so that we all understand the purpose of the real purpose of why I'm here today. I'm not here to oppose or promote Senate Bill 249. I'm here to make sure that in the event that this does pass in its current iteration, that the town of Conway, particularly because that's where I'm involved, but also any municipality within the state, is going to have the ability to make sure that their costs are covered when it comes time to regulate these things, and that is one of the big deals with the whole bill in general. Okay, so an excerpt from Chief Solomon's letter. I am the chief of the Conway Fire Department. As such, I've had numerous interactions with short-term rentals, all of them negative. They currently do not get inspections, and we only see them when there are emergency responses. Every STR I've been in has had life safety problems ranging from lack of smoke and carbon monoxide alarms to bunk rooms and basements with no adequate egress, to improperly installed wood stoves, unmaintained heating systems, etc. Senate Bill 249, as written, does not give fire departments enough access or authority to get these issues corrected and provide for the safety of the guests. And from the experiences that I have had and the things that I have seen, I have to concur with that. It just doesn't go far enough to guarantee the safety of the visitors and the occupants, the tenants of those properties. There is a that they should follow. Very briefly, you move into a long-term rental, you plan on being there for a while, you're going to learn where the circuit breakers are, where the furnace is, and where all of the means of egress are in a very short period of time, because you're going to be there for a while. You might be there 6 months, a year, you might end up there 10 years, doesn't matter. The problem with short-term rentals is that the folks that rent these things rent them for a Friday, Saturday night to Sunday afternoon. They don't care where the furnace is. They're not really sure how to get out in the event of a fire, and they don't know where the circuit breakers might be. So it requires a much higher level of life safety inspection and regulation. And my suggestion would be, and this is where I refer to you to the regulations that I just handed out that we have proposed. If you go down to section I, they refer to a sleeping area having primary egress, secondary means of escape, working smoke detector, and they refer to chapter 24 of NFPA 101, okay? A much more stringent set of regulations than what you have here in your bill, RSA 48A:14, okay? Well, I have read that RSA, and it is very minimal. In plain English, what it says is that if the water comes on and the toilet's flush and you don't have rodents or bugs, it's a habitable structure, okay? There isn't really much more in there than that, and that isn't enough, okay? These regulations that we have drafted and we proposed include things like fire pits, wood burning appliances, making sure you have adequate means of egress in an emergency. you really need to get definition in there based on the NFPA regulations so that these things are safe. The last thing that anybody wants to see is to have a fire in one of these places and everybody gets up and goes, where's the exit? Okay, it's going to be a catastrophe, and these things need to be addressed more adequately. That's the primary reason for my appearance here today. But secondarily, I'm not sure where we're going with the term reasonable amount of money to inspect and monitor and continue to have to deal with these things. Reasonable to one person may be outrageous to another. In Conway, we determined that for the 500 or so of these STRs that we currently have, a reasonable amount of regulation would be somewhere between $300 and $350. And my question is, does that appear to be reasonable under the terms and conditions of this bill? In regulating, and now I have more questions than I do answers to any of this. In regulating, in the terms of regulation here, would this allow towns to limit the number of nights an STR could be rented, or would it allow towns to limit the percentage of STRs versus actual housing stock? In other words, limit the number of STRs that would be allowed within Conway, understanding it certainly would allow them to be anywhere you could put residential housing. That's the purpose of the bill, is to not allow towns to ban them, okay? So those are two questions that I have on that. The short-term rental committee that drafted those regulations had two things in mind when they did that. And number one was the life safety of the occupants. We certainly don't want to have some kind of a catastrophe and have people get injured or worse, die in one of these structures being used as an STR. The second thing, which really is what kind of precipitated this whole thing in the first place, and I think unfortunately Conway was at the forefront of the whole thing when it got started, was the peaceful enjoyment of the neighbors. We have documented areas in town where we have homes that are a 3-bedroom or possibly a 4-bedroom home that have 16, 18, 20, 25 people in there over the weekend, and the neighbors just simply can't enjoy their own backyard. That's what brought this to the forefront to begin with. So I think that this bill does a lot of things, but it needs to specifically guarantee that we're going to have the ability to introduce a stringent enough life safety code so that nobody gets hurt in these, and an ability to govern and regulate these based on noise and occupancy and things of that nature. This goes much further than that. It goes into noise and occupancy. It also takes into consideration septic systems and septic loading, if you're not on a municipal septic system, things of that nature. It takes in parking, trash, caps occupancy, and I guess the main point is, will this type of regulation be allowed under this bill?
Great. Senator Gannon.
Thank you. Well, I appreciate your regulations and safety, and no one wants anyone getting hurt. I and a lot of people are going to be looking to rent out a camp June to September, maybe 4 or 5 times, pick up $5,000, pay for the taxes. Your burden, you're very detailed, and so I'm worrying that maybe someone else is going to be more onerously burdensome than even you are. You talk about places you'd need to. My place, for instance, there's no tire, there's no impervious surface, so I would be violating just in the driveway portion. You're going to make me either tire or gravel it. You have fire pit setbacks. You have number of cars. So like my family, if we all rented a condo for the week and we might have 6 cars there, you're limiting it to 1 per bedroom. So I'm saying if there were 4 people, I'd probably have 4 cars. My kids are all adults, they're gonna come separately. So I'm afraid you're gonna make things very, very burdensome if we don't have some control over your regulations. I just saw fire pit setbacks. I certainly want smoke alarms, but again, with the first people earlier were talking about regulations there, or I think you did, you said it's just water and no rats and a few basic things. So I think there needs to be a balance between, some towns are gonna go, I'll pick Portsmouth for instance, very far, where other towns aren't. And I'm very concerned that you're gonna overregulate. Or you potential to be out of control and really limit someone's use and enjoyment of their property. Just my opinion, you don't even have to comment.
Well, in reference to parking, I think that's referring to overnight parking. I don't think that includes.
Sure, but you said 1 per bedroom in your regulation, so I'm looking at my family, I'd have at least 4 cars there. So I'd be in violation right away. I just saw tons and tons of little things that I thought were very nitpicky.
There are provisions in here also to ask for variances to this under certain conditions, so.
Sure, even, so I have someone renting for a weekend, then they have to go to the town and get a burning they're gonna have to get a fire exemption for having a little fire by the lake in the little pit.
The fire pit regulation is copied from your own New Hampshire RSA. That already exists. It's simply referenced in here. My understanding is, I believe I'm correct, that if you rent your property to an individual, then that individual has to go and apply for a fire permit. So you can't get a fire permit for your property, and the person that's renting it.
So a quick follow-up. So my concern is really not, I just only had a minute to look at what you just handed out, so I don't know all, but I saw a lot of things in here. Another town could take it to another level. And I'm just afraid that towns could get really, really certain towns would get carried away.
Point taken.
Thank you.
Thank you. Any other questions? Seeing none, thank you, Carl, for coming down.
Thank you.
David?
Thank you for having me. I'm David Kavanaugh, homeowner in North Conway. I'm also here representing the Mount Washington Valley Association for Responsible Vacation Rentals. They have elected me president back in May 2021, actually, in response to Conway's vote to prohibit short-term rentals based upon certain conditions. So thanks for allowing me to come here to speak on behalf of all our members, also property rights, property owners who want to preserve their property rights. A big thing could be someone who doesn't rent today but wants to rent in the future. Really, short-term rentals have been going on forever, right? Before our time, towns like Conway were built on vacationers. They brought the train in from Boston, dropped them off right on Main Street. They went skiing, they went shopping, they stayed for a week and went home. We know the story. In Madison, small neighborhood called Edelweiss, they built and advertised in the Boston Globe that these were vacation homes. All right? People bought them up. Fast forward to 2000, people were renting their homes, word of mouth, taking advertisement in Boston Globe. Now we have Airbnb, VRBO, HomeAway, all these different platforms on a website. Sure, it makes it easier. I get it. However, the use has stayed the same. All right? It's really just the marketing platform that has changed. All right? So I'm happy to see state legislation happening, potential for this. Other states are doing the same thing. I know the neighboring state of Vermont, is trying to get something on the state level. It's much better than doing that on a town-by-town basis. Even our Honorable Judge Ignatius has been quoted as saying, let me take a look here. I'd like to say that I can sit quiet for the next few years while the legislation works itself out and have that be the way it gets addressed. However, we know she has a job. She probably has to make a decision. but she's definitely looking, as we are, to get some state legislation. This is the right way. Let's do it from the top down, right? Not be a wild, wild west where each town's gonna, do what they want to do on their own. Like like you were saying about overregulation. We like responsible regulation, but we don't want to go overboard, and we don't want to have each town sort of take it to the next level. So SB 249 is exactly that bill that will allow property owners to maintain their constitutional right to rent and have the towns, have some regulations. This seems to be the happy median that we look for as property rights and in town enforcement. Exactly in the bill, noise, parking, safety, health issues. Of course, we acknowledge some of those exist. However, I don't want to get too carried away with some testimony that people may provide. A lot of this is bad apples. Most of us are reasonable renters. We all love our homes. We take care of them. We make our improvements. We care for our neighbors, and we don't want to ruin relationships and ruin neighborhoods. That's not what we're there for, right? So the bill, I feel, will could create a controlled and monitored rental environment. So my association and all its members are certainly supportive of reasonable regulations. Okay? You keep hearing, another point I want to make is you keep hearing about short-term rentals and its effect on the real estate trends, right? And one of those is the affordable housing, all right? Let's take a look at some numbers. I'm a statistician, so I like to get into the data. We know Conway has about 500 short-term rentals, okay? I believe this number is actually in the 400s based upon some inaccuracies and some outdated information. That's just kind of minute details. But that represents 5% of the housing stock, approximately 5% of the housing stock in Conway. Let's take a look at other vacation neighborhoods or towns. Lake Placid, New York. Stowe, Vermont. Okay? Very similar to a place like Conway, tourist, outdoor recreation, winter skiing, summer mountain biking, etc. They're in the upper teens. They're 15 to 20% of their housing stock is STRs. All right? I've been to these places before. I'm from Western New York. Very comparable to a place like Conway. Let's talk about Crested Butte, Colorado, another place that I've been in my life. Crested Butte, Colorado has a cap on their STRs. It's something that's happened recently. 30% of their housing stock is from STRs. That's a heck of a big difference than 5%. That's where you're seeing the rise of Airbnb, VRBO, the investors coming in. You're not seeing it in Conway where it's 5%. 5% of the housing stock has such a minimal impact on housing, affordable housing, etc. Okay? So let's just get that clear. It's my belief that 5% compared to something that's 30% is a big, big difference. All right? As Senator Bradley pointed out, it's very likely that a second home that's operated as a short-term rental is likely to be out of the affordable housing market anyways. So if I sell my place, I do have a second home. If I sold my place, it's likely that you're exactly right. It's not gonna make it into that sort of demographic of buyer. All right. Last point for me is, of course, being a numbers guy, there is an economic impact from short-term rentals. We saw the economic impact during the pandemic. Restaurants, business owners, small business owners on Main Street or anywhere in the vicinity of the Mount Washington Valley and across New Hampshire, they were affected. Restaurants could only maintain 25% capacity, etc. However, there was government assistance. I don't want to go down the street to my buddy's restaurant in Conway and tell him the town has banned short-term rentals. 30% of your business is not coming here anymore. He's going to have no relief. He's not going to have the piggy bank from the federal government backing him up. So I don't want to be that guy to eliminate 30% of our tourist economy. That's what will happen if short-term rentals are banned. So I'm here to ask for your support of SB 249 to make sure that New Hampshire has a thriving tourist economy for years to come.
Thank you. Questions? Seeing none? Thank you, David.
Thank you.
Chris Vashon?
Morning. Chris Vashon. I now live in Conway, New Hampshire, North Conway, New Hampshire. I'm not a short-term renter. I now live in the house, but my wife and I bought it as a second home, and we're moving up there. So, you know, I grew up in Northfield, New Hampshire, just up the road, Jackson 19. So I'm very familiar with a lot of vacation towns. I went to school in Boulder, Colorado, skied the mountains in Vail, A Basin. I lived in Hermosa Beach, California, the Cape, Portsmouth, Rye, and now Conway. And I grew up in the Lakes region, and I used to live at Weirs Beach in the summers. So I'm very, very familiar what New Hampshire is about and other places around the country. So short-term rentals, that's how we lived, or we went places throughout my whole life, whether it's different parts of the country or around here. We're up in North Conway because of STRs, and it's been great for our family. I have essentially 3 teenagers and my wife and I, and we can't stuff each other into a hotel, okay? We did it in Boulder for a night, and it's just not feasible, okay? You know, so I put together a little packet. I have one for you guys too if you want. It's just some information that I've collected over the last couple of years just studying this. You know, we did do some research on the STR part of it. It wasn't our main focus. We have 3 racers. That's what our focus was. We're up there for our family. But we wanted to have that advantage if we needed it to rent it. And, you know, being from the mortgage and the real estate business, I know what it's like for things to fall apart, okay? I lived it, okay? So without that option, it's kind of a tough thing, a pill to swallow, okay? But we decided to buy this right when COVID hit. We waited a few months and just paid all the bills, and then we bought it once we saw the market was gonna probably stabilize. But it was pretty scary at that time. But we were able to live up there and realized we could live in a house a third the size of the house we lived down in Barrington, and we did it. And we'll probably add on now once we sell our house. But that's the plan that we have. So we are now up in North Conway. Our kids are there. They love it. It's a great place for us. But we did our homework to find out, and people say that, you know, oh, you should have known better. Well, I do know better because when I was looking at, you know, the possibility of renting if I ever needed to, even though it was not on the front burner for me, I'm looking at housing standards, chapter 48A, and it is like really clear to me what it says. And I appreciate this bill because I think it's necessary, because I think it helps clarify people that think it's vague. But it's pretty clear to me when it says 48A1 definitions, it says, and this is from, you know, parts of this is from 1959, 65, some 2017, but it says in vacation rental, a short-term rental, specifically, means any individually or collectively owned single-family house, occupied residential home that is offered for a fee for less than 30 consecutive days. There's a little bit more to it than that, I'm paraphrasing. For purposes of this chapter, vacation rental and short-term rental are residential uses of the property and do not include a unit that is used for any non-residential use, including retail, restaurant, banquet space, blah, blah, blah. Okay, and then it further goes down where I think it was amended for section A2. The power conferred by this section shall not be used to impose any additional ordinances, codes, bylaws, licenses, certificates, or other restrictions on dwellings used as a vacation rental or short-term rental. Okay, it's pretty specific. So did I do my homework? Yeah, I thought I did, but people do what they do, and they put together some articles and made a progression of these articles. And in this case, Conway, I'm talking because that's where I am, to essentially create a progression to create a ban, because if one of those articles didn't pass, it banned short-term rentals. And, you know, I have the data in here from the, how many It was 2019, 7,757 voters, registered voters in Conway. And then I got the ballot with the number of votes, and literally about less than 1,500 people voted. It's less than 20% voted on this. And that's what is supposedly dictating the majority. I mean, I don't think people knew what they were voting on in the first place because these warrants were bad. So I don't want to get in the weeds with that, but I'm just telling you that that's where I'm coming from and why we need to have things done at the state level for you to be granting the powers that the towns should be doing. Like I think you said, Senator French, that this is a republic. Is that right? Okay. I don't think we're a minority because people think of different things about minority, but you know, we don't get to vote. That's fine. I'm not asking to vote. Okay, that's a path I don't think we should take, but we could, I guess. But I don't think we should. I think we just need the bill to clarify it because these things are going into courts. I mean, I'm looking at if you're familiar with the Kearsarge Lighting Precinct, the KLP. Okay, the KLP in February last year told us about their budget for, I believe, about $82,000. $82,000, 1,700 people, I think, maybe 2,000 in that precinct. So they had a budget of $67,000 for a legal budget only, which is 3/4 of the budget. Go figure that. So they spent $574 at that time. I go to the proposed budget in June, and they had already wiped out $40,211 and now asking for an additional $50,000 to fight STRs. So all that means to me is I'm paying taxes, property taxes, using very little of the services, okay, at that time. Now I am because I live there, but all these STRs or second homeowners use very few of the services. And they're having to pay for the lawsuit against them, and we have our association that we have to create a fund to try to defend ourselves on things that are very clear here that state these are residential uses, okay? So if it's going to take the SB 249, I think it was 458 last year, but 249 to clarify this and get everybody on the same page and get us something that we can all live with, okay? Because we, in this association, there's like 1,500 members or something. We're okay with that. You know, I'm hearing numbers thrown around like $300 or $400 or $500. I mean, we don't need a $150,000 fund to maintain a list, okay? For inspections, all you need to do is say, hey, we think this place needs an inspection because we see this, okay? And that takes care of it. Okay, we don't need to go into the weeds on every detail. And I understand where some people are coming from, and I get it, but this bill covers that. If something's up, they can do it. As far as noise ordinances, the town of Durham, New Hampshire, I went to UNH too. So the town of Durham, New Hampshire has a noise ordinance. All you have to do is go to their websites and look at what they do. Okay, it's very similar to, I think, that's what's in 249, but it's like you just keep people responsible. They have a resource officer or some officer that goes around and goes to the fraternities and the houses and everything, and they go around and they educate the people and say, hey, this is your first warning. The next one is going to be this, and if there's another one after that, you guys are out of here, essentially, and you're fined, and we better not hear anything else. Okay, we got to have something with teeth. Totally agree with that, you know, but. The thing is like with short-term rentals, if we're going to do it for short-term rentals, we got to make sure that everybody's accountable too, okay? You know, if the finger's always pointed at us for like we're creating a housing shortage or the employees can't live here, I got to tell you something. I love it. The town of Conway has done an incredible job in marketing the town and building it up, but what they haven't done or haven't been able to keep up with is the building permit. I think there was a 10-year spell, there were less than 200 building permits in the 2010s, 2020. That's not a lot, okay? So I hope this makes some kind of sense. I'll leave this with you. You know, I've got a couple things in here for articles in the Conway Daily Sun, which has helped all of us out a lot to voice things, just looking for accuracy, but this is another area, which is just renters writing in and stating that why rentals are important to them. Because some of them have dogs, some of them have a lot of kids. You know, some of them, you know, say our family grew, as our family grew fond, that hotels were just not enough, so we began renting houses. You know how many people do that? So we, look at it any way you want. We share our houses with people that aren't there yet, like I wasn't there. I was the first one, my wife too, first one on either side to ever own a second home, okay? And it took us a long time, and we worked hard to get there. But you know what? We did get to use other people's houses and pay them a fair amount so that we could at least experience it, created our dreams, and made them come through. So anyways, I really thank you for your time, and I don't know if you have any questions, probably don't, but, you know, I appreciate it, and I'll leave this with the senator.
Give it to Aaron.
Give it to.
Thank you very much. Any questions? Seeing none, thank you, Chris.
Thank you. Appreciate it.
I do have one question. Chris, you referred to a definition of short-term rental. I think you said it was RSA 48.
It's the Housing Standards, Chapter 48A.
Okay, thank you.
It's in here, and I actually was up late last night doing 2 copies of this, so I've highlighted it for you guys if you want, okay?
Yep, that'll be great.
Thank you.
Thea St. Clair? So we've got several people wishing to speak. If you could keep your comments down to 3 minutes or so and try not to repeat what you've already heard, we'd appreciate it.
Yes, Senator French, I understand the time constraints. My ticket is about to run out as it is. And I do not intend to repeat a lot of what's already been said. However, I do feel what I have to present is very important to this committee and to all of the people who are here today. To briefly introduce myself, I am Thais St. Clair. I am president of the Lakes Region's Bed and Breakfast Association. In addition to have owned and run a bed and breakfast for almost 9 years now, I also am the owner of 2 long-term rental properties. I manage a short-term rental property right next door, and I have another short-term rental property directly across the street from my bed and breakfast. I recognize the need for every type of accommodation and housing types of properties in the Lakes region and in the state of New Hampshire, and I am in support of every type, including campgrounds, hotels, boutique motels, bed and breakfasts, short-term rentals, vacation rentals, although I count them as the same. But I believe this bill would not even exist if the proper management of short-term rentals was in place in the first place. We would not be having these legal issues if 5 categories have been addressed from the get-go. I summarize them, and I'm very familiar with them because they're the same as what bed and breakfasts have to contend with. And we are highly we have lots of restrictions, we have licenses, we have ordinances, permits, codes, all of these we have to comply with. I don't believe that short-term rentals can be successful without addressing these 5 areas. They have been mentioned before, so I will be brief. The registration and the inspection is a significant positive step forward in dealing with this whole issue with short-term rentals. However, the wording and the content is not sufficient yet. So I'm asking for continued and additional wording to be added to the amendment. The registration, I believe, needs to be done the owners a sufficient time to make sure that their properties are safe and ready for taking in a wide variety of guests. I think that having somebody in the state who is in the role of service of process is a step in the right direction, but communities really need to have somebody in the same community that is either managing or overseeing or lives in the same town or city where these vacation rentals exist. They need to be available right away in the event of a problem. Listings of the vacation rental should be available upon request to the residents in the communities, and they should be provided to abutting neighbors so that they are aware of what to expect or not expect in their neighboring properties. A fee should be charged for the registration to cover the costs, and it should be updated annually. Situations change, properties change. This needs to be updated on an annual basis. Municipalities should be conducting safety, fire, and building code compliance inspections. This fee could be included with the registration. An occupancy permit should be provided by the towns after registration and after completing the inspection. The occupancy permit should be determining the number of guests allowed to stay overnight and the number of vehicles that can be fit in the available parking space for each of the properties. I will give one example. The vacation rental property right next to my bed and breakfast, they were to have about a dozen guests there. They had an all-night party on a Saturday night. Close to a dozen vehicles were parked along the back road, not on the property, but on the side of the street, which is not allowed in my town. I got a phone call in the morning from my sister who lives behind this vacation rental property, and I was told that the ambulance cannot get there. She was on the verge of having a diabetic, low sugar, and about to go into a diabetic coma. And the ambulance couldn't get there because of all of the vehicles parked along the street. She could have died. Fortunately, I'm within running distance to get to my sister's house, and I ran like hell there to save my sister's life. So, parking, street usage is very important. It has to be regulated by the towns. I have been in vacation rental properties, no smoke detectors, no fire extinguishers, not to mention any kind of fire suppression system, no signage for exits, emergency exits, and so forth, even the types of locks used on doors and how doors are locked between bedrooms and other parts of the house. The list can go on. For the safety of the community and the visitors who come and stay in the short-term rentals has to be evaluated and covered in this bill. I have had trash from a vacation rental property put into a shed and left for nearly a week, and it happened on 3 occasions. Our local bear came out of the woods and took the trash out of the shed, and it got strewn out all over my bed and breakfast property. Sewage. Property owners are not necessarily thinking about the number of people and how much their septic systems or other sewage systems can really handle. And then in addition to the people staying overnight, the people that they invite to come over and have celebrations, parties, events, all-night parties, is adding to the usage of the septic or sewage systems, and owners are not aware of a lot of this going on. Fire permits is handled separately by the state of New Hampshire. I won't comment on that. Some bed and breakfasts, and I'm sorry, some vacation rentals do offer breakfast or other meal services, but they're not licensed for food service. This needs to be addressed. Noise and events. Vacation rental across the street from me had wedding after wedding after wedding with a big tent, noise like you wouldn't believe, fireworks, even the DJ from the wedding, I could still hear it at my property at 12 o'clock at night when most of my guests have already gone to bed. So the noise ordinances need to be, towns need to be able to have them in place and able to enforce them. And the fifth point that I'm going to bring up is the community housing needs. There has been discussion already about low-income housing. That's not my point. My point is long-term rental versus short-term rental. In my community, the number of long-term rentals has decreased considerably. Towns need to have the ability to provide the type of housing needs for their communities, and if they have to limit the number of short-term rentals so there's sufficient long-term rentals, they should be able to have that ability to do so. These are the 5 key areas that this committee needs to address. It needs to be written into the amendment so that we can have safe, peaceful communities and be able to have both long-term and short-term rentals, vacation rentals. And it's not just the online platforms of VRBO and Airbnb, which I do list on as well myself, but it's also the real estate agencies that do property management. It involves all of these parties. Thank you. Are there any questions?
Thank you. Any questions from the committee? Seeing none, thank you for coming in.
Okay. Thank you very much.
Susan Matheson, did you want to speak?
Thanks. I'm Susan Matheson. Rentals or not, the question about this bill is how are towns allowed to regulate, enforce, and deal with the effects of people living in our towns, whether they be short-term tenants, long-term tenants, owners. Zoning is the wrong thing. Before I bought both of my short-term rentals, beginning 6 years ago, I went to the town and asked if they were allowed in the zoning that they were in, one in multifamily and one in the ag zone, and was told, yes, of course, short-term renters are allowed in both of these zones. Proceeded with the purchases. A new town planner has come and has determined that all short-term rentals in all zones are illegal. So in other words, my short-term rental in the ag zone, which happens to be an old Grange Hall that I have gutted and restored and placed on the National Register of Historic Places and the State Register, is an illegal use. I cannot share that, according to our town planner, according to their interpretation of zoning. I cannot share that National Register property, nor take advantage of the historic tax credits that come along with the renovation of over $120,000, because she has determined that short-term rentals are not allowed in any zone. Now, I could have taken that Grange and made a cluster development, a retirement community, a 2-family dwelling, a public recreation facility, an auto repair shop, a gas station, a bank, a child care center, a drive-through restaurant, a hotel, a motel, a sit-down restaurant, a theater, or a car sales lot. But I can't offer it to the public to come and spend the night. And anyone else in the ag zone, if they have a spare bedroom, they can't offer a spare bedroom under short-term rental because of the zoning restrictions. However, they could open a 24-hour car repair shop. Zoning is the wrong approach for regulating short-term rentals. My other short-term rental, which I've had for 6 years, is in a multifamily residential zone. She's also telling me it's an illegal use. In 6 years, I'm a superhost. I have a very high occupancy rate. I've never had a single complaint about my small 700 square foot home. I host visiting nurses for the local hospital. Seems like that's something a community wants to have, is a place for a visiting nurse in a pandemic to come and help out our communities. According to her, I have an illegal use in my 700 square foot short-term rental. I could turn around and rent it to 3 unrelated college students and their cars and their noise, and that would be fine. So regulating the use of short-term rentals and giving the short-term rental this broad brush as offensive is the wrong approach. The bill is correct. Regulate the effects, regulate the noise, regulate the sanitation, regulate the life safety through your town, but not through zoning. I bought these properties deliberately and carefully. I preserved 2 historic structures, one on the register, making them available to the public and supporting our tourism industry. I've never had a single complaint. I'm a superhost, but broad brushing these short-term rentals as illegal through all zones is the wrong approach. Instead, regulate and enforce the effects, noise, sanitation, parking, just as the town would with any other property use, not via outright bans through zoning.
Thank you. So, one question. So these units you have that you can't rent out, you could loan them out to anyone you wanted for any duration of time,
Sure, my
couldn't
friends
you?
could come and stay there for a weekend.
And you could do it multiple times for any duration, but the minute you go to receive compensation for that, that's when it becomes illegal.
Yes.
Great, thanks. Any questions? Thank you very much. Nathan?
I gotta double check my watch. I think it's still morning, so.
Yeah, it is. You got 5 minutes.
Good morning, Mr. Chairman, members of the committee. My name is Nathan Fennessy. I'm an attorney in Concord. I'm here today representing the Mount Washington Valley Association for Responsible Vacation Rentals. I've also represented a number of different owners of short-term rentals before various boards and in litigation as well here in New Hampshire. I've come today speaking in support of SB 249. I want to thank the chairman for sponsoring the bill. I've seen the amendment and I've spoken with the president of the association, and we're fine with the amendment. We think it's great. We think it improves the bill, definitely gives municipalities some additional regulatory authority, which we're fine with. I want to thank the other members of the committee for co-sponsoring the bill. We think this is a reasonable compromise between the owners who want to be able to offer, primarily, our members are primarily secondary homeowners who use their places for some period of time, and then when they're not using them, they want to have the opportunity to rent them out to people. As Senator Gannon mentioned, these are people who do care about their neighbors. They're up there, they're enjoying the lakes region or the mountains, and they want to have the opportunity to do so, but they also want to have the opportunity to share it with others. And I think, it certainly serves our community here in New Hampshire to be welcoming and to invite people to come in. I personally, I have 3 kids, so when we go on vacation, it's really hard to go into a hotel room. We're primarily doing some sort of a short-term rental, whether it's a condo or a house, maybe we're going with another family. That's a reasonable way to do it. To the best of my knowledge, we've never been a problem since we're all in bed by 9 o'clock. So while members of the association are certainly cognizant of the issues that arise, it's not just the short-term rentals that are causing these issues. Sometimes it's a long-term renter. Sometimes it's college students who are just, borrowing the cottage for the weekend. As you know, short-term rentals are nothing new in New Hampshire. When I was young, my grandparents had a place on Mountain View Lake, which most of you probably don't know, but it's on Route 103, about a mile from Mount Sunapee. We would rent a cottage for a week so we could go see my grandparents. And cottages on that lake, when it wasn't the summer, they were getting rented for long weekends or weeks in the winter so people could go skiing at Mount Sunapee. This is not something new. What's new is, and I think you just heard about it from our last speaker, is that municipalities are reinterpreting their zoning ordinances to prohibit this use. I'll give you one example, which I think the president of the association mentioned earlier. In Madison, the day after Christmas, they sent out cease and desist letters to 70 owners of properties claiming that they were now in violation of their zoning ordinance because they were offering their homes as short-term rentals. Obviously, there's a process that needs to go through. I will share with you that the same zoning ordinance which they claim prohibits the rental of units in this residential district also explicitly allows the rental of accessory dwelling units in the district. So we have a disconnect between what the words say and how they're being interpreted. And as some of you may know, our firm's been involved in representing people involved with the town of Conway and other places. The members of the association that I represent want to be good neighbors. They want to have reasonable regulation with respect to, health, life, and safety. The problem, and I think we heard a little bit from the select board member from Conway, is that some of these towns want to treat your, second home, which you may rent out for once or twice during the year, maybe 3 or 4, who knows, but they want to treat it differently as the residential single-family home right next door. To a point, that's okay, but when you start putting prohibitions on how many cars, how many fire extinguishers need to be in, now we're starting to pick and choose 2 houses that, when you stand outside, are exactly the same, being used for the same purpose. So we think that the amendment is great. We think it's improved the bill, and we hope the committee moves forward with SB 249. Happy to take any questions.
Questions, Senator Bradley?
Thank you very much. Would you address what is commonly known in zoning parlance as pre-existing non-conforming rights and how that affects property owners that we've heard significant testimony of rented on a short-term basis prior to the platforms?
Sure. So in most towns, you have the opportunity to do certain things. You may have, for example, rented as a short-term rental for years. In some cases, I know of situations where people have rented these as short-term rentals before there was even zoning in their town. So that's going to be a lawful non-conforming use because it was okay at the time which you started before there was any zoning. What we have seen is the situation where the zoning may be in place, but the interpretation has changed at this point. And in most places, if you've been doing something for example, 10 years, then it's perceived as being a lawful non-conforming use. And so where that comes up tends to be where there's enforcement. So if the town comes in and wants to, for example, impose some sort of penalties or fees, then you can make the argument, no, we've had a lawful non-conforming use and we're outside of that.
Thank you.
Senator Gannon.
Thanks for taking my question. It's following up with my earlier thoughts. I don't want to be unduly burdened by an overly zealous town. So does line 29 protect me from that in the amendment where it says the minimum housing standards in RSA? So is that going to keep them from having, you have to have a trash can 15 feet in, it has to have this lid, and it has to be this and this and this, and it's just going to be an endless burden. They talked about impervious services. Are they going to be able to do that, or are they going to have to treat me like the house next door?
under this in that line?
Sure. As I understand it, and I've only had the benefit of the amendment for maybe an hour now, but that reference to the minimum housing standards are the minimum housing standards, which I think one of the previous people who testified referred to, and you might have even been provided with a copy of that. Those are the minimum standards for a house or housing property, which the town, I'll say town, has the ability to enforce. There's also a reference here to fire warning device and carbon monoxide detection device as required under RSA 15310A2. That's a slightly different, that's probably over and above what would be the minimum standards under 48A14. But
Quick follow-up, so just if I can understand, they're not going to be able to have 552 regulations that are more burdensome than me than they are doing to my neighbor who is not renting?
that's how I read the proposed amendment.
Thank you.
Yes.
Thank you.
Thank you. No more questions? Thank you very much.
Thank you.
Susan? Cragen? Heidi?
Good afternoon.
Good morning.
Thank you.
Afternoon.
I'll keep it short.
Thank you.
My name is Heidi Milbrand. I own and operate Pleasant View Bed and Breakfast in Bristol. I'm also the president of the New Hampshire Bed and Breakfast Association, and I also sit on the board of directors of the New Hampshire Lodging and Restaurant Association. And a little side note, pardon me. Innkeeping has been around since before the birth of Jesus. We're one of the second oldest professions. And these, as far as I'm concerned, Airbnb, VRBO, and realtors are just fly-by-night operations. I'm highly disappointed in this bill, and I oppose it on principle. Once again, you show no concern for legitimate small business lodging owners. It seems as if you want us to go out of business. This bill basically says anyone can take their home and use it as a short-term rental. And yes, I am considered a short-term rental with no regard to licenses, rules, or regulations. Sure, the bill indicates that a municipality may enact an ordinance which requires an inspection of the property and to determine if the property meets the minimum housing standards. Do you honestly think towns, especially the smaller ones, are going to hire someone to follow up on these brand new lodging places? And worse yet, this bill opens the door for investors to purchase multiple cheap buildings and rent them out without any oversight. To be a legitimate bed and breakfast, the state makes us hit certain benchmarks. It needs to be owner occupied, and nowhere in this bill indicates that a person must live there. Defined in the RSA regarding bed and breakfast, we need to have a minimum of 4 rooms to rent, and breakfast is included in the room rate. We need to have our kitchens licensed and inspected. We also collect meals and rentals for the state. Nowhere in this bill does it indicate that they need to collect meals and rentals. Will they be required to? It seems that the supporters of this bill are more concerned about the owners not having to pay a lot on their taxes. If that's the case, then I'm going to propose that my 40-plus members, as well as others that are not members of my association, not be required to collect meals and rentals. We need to carry commercial insurance, and depending on the city or town, we need to have sprinkler systems. Some must be hardwired to a security system. I am. My system's directly linked to my town's fire department. Some need boiler inspections. I've received no complaints about my business. However, if you look at police call logs, even do a Google search, which I did, on Airbnb complaints, there's over 200,000 complaints. A lot of the complaints are made from homeowners who have the misfortune living next to one of these short-term rentals. Calls include excessive noise, more traffic, parking issues, and general disruption to the neighborhood. My neighbors know I run a clean, safe, and quiet place. I have 4 abutting neighbors. So if you pass this bill, then theoretically, they'll be able to rent their houses every night of the week to a different person or group, severely undercutting my legitimate business, which to open and run, I've had to follow all state regs and zoning ordinances. One final thought. The gentleman that spoke about the Mount Washington homeowners' rights or whatever, he said that the small businesses during the shutdown were impacted. Well, guess what? So was I. I was shut down for 5 months, not able to make any sort of income. But yet, every single person in my town that had an Airbnb or VRBO, they were allowed to stay open and keep collecting money. I was shut down. Again, are you trying to shut me out of business? Thank you.
Thank you. Any
Questions?
questions? No one dares to. Thank you.
Thanks.
Don?
Good afternoon, Senators. My name's Don Milbrand. I live in Bristol. Full disclosure of any financial issues, my wife, I think, just addressed. I've been on the select board in Bristol for 11 years. I'm currently the chair. I've been on planning board in Bristol for 16 years. I'm not here representing Bristol in any way. I'm here as a citizen concerned with basically town's rights. Everyone here knows that there's no local rule in New Hampshire. Everything is dictated by the state. I'd like the committee to look at this bill on a slightly higher level when you're completing your deliberations on it. And that is of the state allowing towns to have local regulations and rights. What I see in this bill is an effort to correct a problem at the spur of a moment, possibly. If I was looking at this on the planning board and looking at the contents of this bill, I would consider it very bad zoning ordinance. I know that there's been several amendments to try and correct some of these situations, but I would like you to look at this as, instead of trying to nitpick and dictate all the details of it, look at it at a higher level to give towns a guideline as to what should be done in this area, and then allow all the separate towns to make the regulations according to their own needs. If you look across this state, Colebrook, Antrim, Warner, Bristol, Portsmouth, Nashua, Peterborough, all these towns have different needs. They have different requirements. They have different, they'll have different people coming in for short-term rentals. Somebody at the lake in Bristol is probably going to be very similar to the gentleman, the mayor and town manager from Laconia. I actually plan on planning board, because we've been wrestling with this issue already on how to regulate short-term rentals in Bristol in a good manner. I think Laconia, what I've seen, is a very good boilerplate for all towns. Will we copy that exactly? No, because our needs are different than Laconia. Will we take that and tailor it to our own needs? Yes. Should Conway take that and tailor it to their needs? Yes. I think that's where this committee needs to guide and provide a big overview for the towns to tailor the individual needs for their own individual situation. Thank you very much.
Thank you. Any questions? None. Thank you very much. Teresa?
I'm going to pass.
Thank you. Krista?
I've got a frog in my throat, so excuse me.
Have some water.
Good afternoon, Senators. My name is Krista Carnan. I was born and raised in Guilford, New Hampshire. I went to Plymouth State University, and I own a home in the Mount Washington Valley where I live and work and play. I'm the Director of Growth and Development for Keller Williams Coastal and Lakes and Mountains Realty in North Conway. I also serve on the Board of Directors for the White Mountain Board of Realtors, where I'm co-chair of the Communications Committee, and am active within the Community Service Committee as well. I'm here to speak in favor of Senate Bill 249 because I feel it offers our towns reasonable regulation of quality of life and safety issues while protecting my personal property rights to rent as I see fit. When I was 24 years old, I tragically lost my mother. After we laid my mom to rest, my dad flew out west to be with his brothers and best friends to figure out how to move forward after such a tragedy. It was too painful for him to stay in his marital home, and he was not in a good enough headspace to make the huge financial decision to sell. With the guidance of a family friend in real estate, my dad was able to short-term rent his marital home while he figured out how to pick up the pieces after losing his wife of 30 years. Meanwhile, he was able to short-term rent someone else's home halfway across the country so he could grieve in comfort. Without the right to short-term rent his own property, my then 60-year-old father would have either gone bankrupt or lost the house that he built with his own two hands for his growing family when he was my age. The bundle of rights began in property law in the late 19th century, and it describes the set of legal rights associated with ownership of real property. There are 5 pillars to the bundle of rights, one of which is the right to control, which states, and I quote, "The right of control is your right to use or control the use of your property. This could include things like making renovations or changes to the property, having guests over to visit or live with you, or renting it out to earn an income." End quote. I'm very concerned by the attempts of some of our towns to limit the use of my property. I know that my property rights are instilled in both the United States Constitution and the New Hampshire Constitution. Denying an owner from legally renting their single-family home is an illegal taking without due compensation under the Fifth Amendment to the United States Constitution and New Hampshire RSA 498-A with no clear public benefit. This is why I support this bill as a well-thought-out compromise that protects my property rights while simultaneously giving the towns the tools that they need that they don't currently have to regulate short-term rentals. I appreciate your time. Thanks for listening.
Thank you. Any questions? Seeing none, thank you very much.
Thank you very much.
Carrie? Not here? Oh, back there.
So I actually came down here for another agent in our valley, and she's actually a single mom. I'll give you this. That's her story to read.
Would you introduce yourself?
Yeah, absolutely. My
Thank
name's
you.
Carrie Erickson. I am a realtor and a born and raised girl from Conway, New Hampshire. So I'm coming down here to present this letter, like I said, for a single mom who, through short-term rentals, after losing her husband, was able to keep her children in the area that they knew. They were born, raised, and were able to continue their life. I also come and speak as somebody, again, who, like I said, was born and raised in a tourist industry area. Prior to selling real estate, which I do now, I was a bartender, I was a waitress, I worked at Storyland, I sold retail. So the number of people that I have experienced in my 20 years of working have come up to our area to enjoy the short-term rentals. There are absolutely folks who stay at inns and Airbnb, or inns and motels versus short-term rentals. But also as a mom, I can tell you that going on vacations with my 2 children, I look at a short-term rental because in my experience with hotels with children, they can't be a child. They are asked to be quiet. My kids are up at 6 a.m. every day. So the 8 a.m. quiet hours for 2 hours trying to get them to sit perfectly still in a hotel, it's almost impossible. The other fact that I factor in is, again, as my husband and I have to go on a vacation, we can't afford to go out for dinner, to go out for lunch, to go out for, breakfast. Everything costs us more. Whereas if we're in a short-term home, we feel at home. We feel we can be ourselves. We can enjoy the area we're in. So I absolutely support this bill, and I believe that allowing regulations can make the people who live there year-round enjoy their property, but it also allows other people to come to our area and enjoy what we offer. If we as a valley didn't have short-term rentals, I don't know how I would have even made it through my high school years, my early 20s, and into my 30s. They paid my mortgage, they paid my car payment. And yes, I could go move somewhere else and this couldn't happen, but I don't think banning them is gonna make it I just think at the end of the day, we have to make everybody happy. We need to make the short-term renters happy. We also need to make the local people happy. If we can find a balance, I'm game. I just want to say I support it, and I'm thankful that we've had this in my area to allow me to raise my family where I am.
Thank you. Any questions? Seeing none? Thank you. We have Deborah and Bill Sullivan. Are you together?
Yes,
Could you stay together and testify together?
I'd like to stay together. 25 years he hasn't dumped me yet.
That was the other courtroom.
Yeah, right?
Thank you. Thank you for giving us the time
Thank
today.
you.
So,
Could you just introduce yourself for the record?
sure.
Thank
Yep. My name's Deb Sullivan, and I live on Tate Road in Guilford, New Hampshire. So I'm just here as a citizen.
Sorry, Bill.
Okay. This is the way it is at home.
Yeah, I can see that.
So I'm here as a citizen, and it's really interesting to see the process, and I appreciate the amendment that you've put forward, Senator French. I think that that it's a start. I do stand in opposition to the bill, and I don't think that this amendment goes far enough. And it's interesting to hear the testimony of the people in Concord with the outright bans and the concerns from the individuals in Concord. I think that this proves that what's happening in Concord is very different than the situations that we're dealing with in Guilford. Oh, yes, I meant Conway. Yeah, I'm sorry.
That's fine.
And
Thanks, Bill.
yeah, it probably does. So I think that that gives credence to my position is that the cities and towns know what's best for their community. So when you hear about like fire pits, where I live in my community in Guilford, there are no fire hydrants. There's one fire hydrant in the beginning of the association, and there are no fire hydrants anywhere else. We've gone by short-term rental properties where people have pulled the fire pits up onto the porch and have fires going on the porch. It's a completely residential neighborhood, and I do agree with the premise of short-term rentals. You know, when we first started coming to the Lakes region, we camped, and then we got the trailer, and then we rented a cottage and eventually bought in the neighborhood that we live in. But I think it's about peaceful coexistence. I don't think, in Guilford, we tried to figure it out. We worked with the zoning and the planning board, and we tried to figure it out, and we didn't quite get there either. So I don't think that it's about complete elimination, but I think it's about peaceful coexistence, right? So the issues of regulation and the ability to enforce, I think, are best made by the cities and towns. I think that the voters have a legitimate say in what happens. I think that, you know, the concerns about high occupancy levels is very real. We should have regulations that are based on septic capacity. Egress is certainly, I mean, when I look at this first, number 6, it seems as though you could take a barn and put in bunk beds and space heaters, and that would be acceptable. And there are some people that might try to do that, which is the frightening thing. And so I do think that this is a situation that is best handled by the local communities and towns. Thank you.
Great, thank you.
Bill, I don't know.
Bill, do you have anything?
Yes, hi. Bill Sullivan, I'm in Tate Road, Guilford. And like my wife said, we worked with the planning board to try to come up with some zoning ordinances so that we could kind of control the short-term rentals, because a lot of the neighbors are complaining about all the noise and all the traffic and all the trash and all the disturbances. And then there were those other concerns with fires and misuse of properties. And so Guilford came up with a plan that they would be able to create an ordinance that would determine how many people could safely live in that house. When you have a house like mine, it's a 3-bedroom, and there's just the 2 of us, but when my kids come up, there's 10 people there. So when there's 10 people there, that's, you know, my septic system can handle 10 people using it regularly for maybe a week,
More than that, it's gonna overflow, it's gonna go right down to the brook behind me, that's gonna go right into Winnipesaukee, and you're gonna pollute the system. That's happening, or could be happening throughout the whole section where I live, but nobody would know, because nobody gets to look at it, nobody gets to check it, nobody brings up any issues. The only issues that are at the forefront are how it's impacting me right now. But there's environmental concerns with septic systems and overloading of buildings and overloading properties where now all your resources are impacted. Your police are busier, your fire could be busier. There's a lot more issues that come up when there's overcrowding of houses. If a house is designed for 6 people, then yeah, maybe you can let it go to 8 to 10 if it's only for a short term, but you can't let that happen every single day and not expect something to happen. So you hear a lot of people say, well, it's my right to vote. It's my right to rent my property and do what I want with my property. Yeah, it is, but it's limited by government. Government says, yeah, you can have a house, you can build a house there, but you can't put a business there. That's zoned for business, for residential only. You can't even put a house on a residential zone unless I see from hearing everybody, and I feel bad, is that there seem to have been certain municipalities that went too far on the other side and said, we're going to limit them completely. Well, that's no good either. So our concern, the reason we came here is we were working well with our town. We were going to get somewhere, and we actually had a town meeting to view the ordinance, and all the people that were against regulation came out and spoke, which was fine. Most of them weren't New Hampshire residents. Most of them weren't residents there. Half of them weren't New Hampshire residents. They didn't even live in New Hampshire. But they had a say at a town hearing, and the board decided, you know what, we got to look at this, because there are some issues that we don't want to affect those people. We don't want to affect the people that are renting it to help pay their taxes. But we don't want those people that are renting, because everybody's a great renter. You hear it, everybody, we rent to the finest people. Everybody has good intentions. That isn't what's happening. What's happening is neighborhoods are being uprooted because of the overflow of the short-term rentals with the absentee tenant, the absentee landlord. If the landlord wasn't absentee, maybe things would be different, but there's all kinds of issues. There's no way to correct them unless you let the towns create ordinances to keep it in line. Your problem, I guess, is to figure out how you can keep those other towns that want to just eliminate them from just eliminating them through ordinance. Thank you for your time.
Great, thank you. Any questions? Seeing none, thank you for coming over.
Thank you very much.
Thank you so much.
So that's all I had on the list of speakers, people wishing to speak. Is there anyone else wishing? Bill, here we go. Yeah.
I have questions of Ms. Burns, so if, I know we probably have to vacate this room.
We do, that's the problem, Senator. We have to be out of here by 12:45 at the latest. I hate to call this, I hate to recess and then reschedule.
Well,
Can we just put a limit? Is there any way to
that's what I'm gonna do. That's what I'm gonna ask. If you can keep it to 1 minute, we can get through everyone. Did you have a question of someone?
I have a question of Ms. Burns from the Municipal Association.
Okay. Would you? Thank you. Aaron, do you have that list? Okay. I'm timing. Go.
But I don't know what my time is.
1 minute.
All right, good morning. I'm Margaret Burns with the New Hampshire Municipal Association, and we are here in opposition to Senate Bill 249. I'd like to start by recognizing the amendment, and thank you, Senator French, for the amendment. It was a step in the right direction, but we are still opposed to some of the provisions in the amendment and are very interested in, I have a lot of testimony to share, but I'm going to try to pare it down here a little bit for you. At its very fundamental level, zoning is the separation of uses, and it is one of the most fundamental aspects of municipal authority, zoning ordinances and zoning provisions. Separation of residential uses and commercial uses is really at the core of what zoning ordinances do. To that end, every use is able to be regulated to some extent by municipal zoning, with one exception, and that's a narrow exception for an agricultural use found in the land use statutes. However, Senate Bill 249 would carve out an exceptional exception, making short-term rentals not subject to any level of zoning regulation. And this would apply to short-term rentals whether they are owner-occupied properties that are just rented a couple weeks, few weeks of the year, and would also apply to rentals that are bought by out-of-state investors and used primarily or solely as income-generating rental properties. We've heard in the past the argument that residential, that the short-term rentals are really just residential property uses, and there's really no difference between a residential property use and using that property as a short-term rental. But that's not what we're seeing in the communities. We're seeing properties be snapped up to be used primarily or solely as commercial rental properties. And I would also suggest to you that while we heard about owners using short-term rentals in responsible ways or not renting out for most of the year and only part of the year, it's the communities and the municipalities where the short-term rentals have led to issues that have then sought to put in some level of zoning regulation or other regulation.
Thank you. In fact, the majority of New Hampshire municipalities do not actually regulate short-term rentals. Instead, what we're seeing is responses to issues that do come up with short-term rentals, and I think that only underscores why it should be left to the local level. I have a lot more I want to say, but I am sure I am well over the minute, and Senator Bradley has questions.
Senator Bradley. Yeah, my first question, similar question to the one I asked of the attorney representing the Mount Washington Valley Association. Having heard the testimony that you've heard today about this use before the platforms, about pre-existing use of it before any enforcement action, or as some people have talked about, reinterpretation of zoning, aren't you concerned about the rights that are conferred through zoning regulations for pre-existing uses, whether they're conforming or not non-conforming?
So the question is, am I concerned about the pre-existing uses of the properties as short-term rentals? Certainly, there is fairly well-settled law on non-conforming pre-existing uses and their ability to continue even once a zoning ordinance has been changed. I heard some testimony perhaps about zoning ordinances being reinterpreted or interpreted differently than they had been in the past. I guess all I would add to that is an important reality of what a zoning ordinance is. In New Hampshire, most zoning ordinances are what's called permissive zoning ordinances. And a permissive zoning ordinance fundamentally means that unless the use is allowed per the zoning ordinance, unless it says it's allowed per the zoning ordinance, then the use is not actually allowed. So in the scenario that was included in prior testimony, it's just hard for me to say whether the zoning ordinances is being reinterpreted or whether the zoning ordinances has never allowed the use of short-term rental properties in that particular community.
But wouldn't you agree with me that the lack of enforcement, regardless of permissive, non-permissive, pre-existing, non-pre-existing, however, creates the kind of situation that we have across New Hampshire now with litigation that is going to be ongoing for a number of years, potentially, given the volume of the number of people doing this, it's going to lead to federal litigation. Aren't you concerned about that?
I won't disagree that that is creating an issue in some communities and that it could create an issue.
And my last question.
Go right ahead.
Having worked with you on Senate Bill 99 last year that triggered a 30% guarantee of rooms and meals tax, and the testimony that we heard today at least $20 million annually and $40 million per budget, aren't you concerned if towns absolutely ban short-term rentals, to say nothing of the impact on tourism in New Hampshire, but just on that provisional loan, 30% of which is going back to towns? Isn't that a concern?
You'll get no argument with me on the importance of the Meals and Rooms tax in New Hampshire and the importance of the legislation that was passed last year to increase the municipal percentage. I will add, though, that bed and breakfast, hotels, restaurants, and food service establishments have all been operating per zoning ordinances, per regulations for many, many years and paying the Meals and Rooms tax. And short-term rentals are able to do the same.
All set. Thank you very much.
Thank you.
So we're going to go front row, left to right, and you all set. Please keep it to about a minute. I do want to get everyone through.
It will be even less. Senators, thank you very much for the opportunity to speak. My name is Julie Arison Bishop. My family and I are property owners in Silver Lake. And my family and I agree with responsible regulations for short-term rentals. Our family takes respect for our neighbors and community seriously, and we welcome the opportunity to work with our town to regulate. That said, I am against banning short-term rentals in the state. We spend $10,000 to $15,000 annually with local contractors to ensure a high standard of care and safety for our property. We use a Madison-based caretaker since taking ownership of our property. This person can respond to a water leak or take a drive-by if we suspect that anything with our property is wrong. Our landscaper is Madison-based, someone who helps us with trash removal to ensure that our property is sanitary and clean. Our housekeeper is a single mother who balances her small business dreams with the ability to care for her child and an ill father. Our home has welcomed families from across the country and across Route 41. We have provided housing for people who have had homes under construction and for people who are visiting family locally in Madison who would not have another place to stay. We polled our renters over the last 2 years and have been told that on a weekend, the local spend in stores, restaurants, and attractions is approximately $750 to $1,000, and in a week-long stay is approximately $1,500 to $2,000, not including the cost of their rental of our home. I would also encourage you, as the Commerce Committee, to reach out to Visit New Hampshire. Ask them about Visa credit card data. Visa credit card data will give you an excellent list of zip codes people are coming from, spending that's related to direct tourism spending, but also that indirect spending as well. And you'll get a really great financial picture as to what that looks like. And if Visit New Hampshire needs support with that, they can reach out to the Massachusetts Office of Travel and Tourism. They have resources that I'm sure they'd be willing to share for that. I don't want to see local businesses suffer. I don't want to see our town's tax base suffer. And I don't want to see a decrease in the amount of meals and rentals tax that supports all New Hampshire towns. We thank you for your support of this legislation and for this amendment, and we hope that you will continue to help keep New Hampshire's economy alive and well.
Thank you.
Assuming no questions. Thank you.
This speed dating democracy.
I know, right?
I'm Paul Mayer
Sorry.
from Bartlett, and I'm going to submit my written comments regarding the economic impact study that came around. And I just want to comment on a few other comments that were made. The comment that the legislation doesn't include a mandate for rooms and meals tax. It doesn't need to, since RSA 78 already has that legislation. These are not just used for party houses. My unit was used during COVID when it was shut down. We got a special exemption to house domestic violence families, and we donated our units to a group called Starting Point in the Mount Washington Valley. On the other issue of permitted zoning, there are lots of things that are legal that are not permitted in residential, or that are permitted in residential zones that are not specifically mentioned in zoning. I'm thinking seasonal zoning, month-to-month zoning, J2 visas, visiting nurses. There's a lot of stuff that doesn't need to be in there. If it's residential, it can be allowed in a residential zone, and that's what SB 249 does. I also want to congratulate you on not being tempted to legislate all the regulations regarding short-term rentals in this bill. I think the bill is to get short-term rentals on the table, and then to allow each town, whether it be Concord or Chatham, to do what's right for their town through the ballot. Thank you very much.
Thank you very much. Thank you.
Good afternoon now. Matt Johnson, Divine Millimet. I'm counsel of New Hampshire Association of Realtors.
Couple quick points. One, I've been here all morning. I have not heard anyone testify that short-term rentals should be banned, so I think we should keep that in context. Two other points to make relative to zoning. I disagree with the Municipal Association. These units only, this bill only applies to single-family and two-family homes. Those do get zoned. They get zoned as residences. So we're not abrogating the zoning. We're just saying that a single-family home that is already zoned as a residence, because someone wants to use it on a short-term rental basis or a long-term rental basis, doesn't get a separate and entirely different set of rules. And the other point I would make is, look at RSA 48A 14 and 48A2. A2 says you can't treat short-term rentals differently, so the legislature's already answered that question. And 4814 is the minimum standard. Senator Gannon had some questions about that. Those are the minimum standards for short-term and long-term. All we're trying to do is treat them the same as long-term rentals. Thank you.
Wow, that was fast. Sorry you had to wait so long.
It's okay.
Thank you. Sir. Oh, yeah. Ma'am.
All right.
I know. What'd you do, drop it? There's 55 names on there.
Good afternoon.
Hi.
I'm Renee Harendine. I am a homeowner in Madison, New Hampshire. And Senator Gannon, to your point about Fifth Amendment, that was taken from us and we have not been compensated. There's about 83 of us that were sent cease and desist letters back in December. And we're now fighting the fight. There's about 43 of us that have appealed so far. And we are looking at a hearing in February. But the town of Madison started, there's the selectmen, there's the planning board, and there's the zoning board. And they all had different opinions on what should happen. So the planning board, they're putting a vote forward on defining a short-term rental for March. The zoning board was going to wait until what happened in Conway to see what was going to happen. And then we had this board of selectmen that went ahead and sent out these cease and desist letters. So now that's what we're dealing with. So I am in full support of this bill in order to properly regulate. I've no incidents at my house, just to say, but I'm in full support. Thank you so much.
Thank you. Sir?
Howard Epstein from Guilford, lead commissioner, water commissioner. I submitted my testimony. I'll speak not on that, though.
Safe.
I'll spare you the burden. I just feel that any regulation that is, and I thank you for doing the amendment, Senator French. I mean, I know it's a lot of work, okay? But I just feel that any sort of regulation is by the state is not going to work for the individual towns. How can you take an owner-occupied Airbnb versus a Airbnb that is owned by a corporation versus an Airbnb where the neighbor is right there next door? You can't, but the towns can. The towns can regulate that, okay? And that is what I'm saying.
Yep.
I don't think, I know for a fact that the town of Guilford is very different than the town of the city of Laconia, right down the street. City of Laconia has sewer in its zones. Town of Guilford doesn't. We're all, well, there's one street that does, Leisure Drive, because it's over by Poorbrook Farm where the state has a right of way, okay? That's the only street in Guilford that has sewer. The rest of us are all on septic systems.
Thank you so much. Anyone? Sorry, we lost the list. I didn't realize there were so many looking to speak. Oh, yeah, we found it.
Okay. Well, good afternoon, senators and chair. My name is Ann Bordiano, and I sent you written testimony. I'm from the town of Sunapee, and I'm a full-time resident there in Sunapee. And I'm also a short-term rental owner, not in New Hampshire, but elsewhere, but I understand the business. I'm here to represent myself. I'm also here to represent 9 of my neighbors who filed the formal complaint to the town of Sunapee, which I had also sent to you as well, regarding a particular short-term rental, which is right next door to me. And I'm also here to represent the Sunapee Short-Term Rental Alliance that we have put together in the town of Sunapee, which is made up of citizens of Sunapee. You know, some of them own short-term rentals, and some citizens don't. So we're trying to have a good group of people that represent our town's interest to work together with town officials. And we're working with the town manager, as well as the police and fire and other different officials in our town, to try to get a handle on what is going on with our town, which is similar to other towns in New Hampshire as well as throughout the country as far as short-term rentals. I am not in support of the original bill, but I do really appreciate the revision that you put together. I'm obviously very much in support of short-term rentals, but I think the 80-20 rules here, I think 80% of the problems are due to 20% of the short-term rentals. And, you know, I think that, you know, from what I've heard from everybody today is, yes, we're all in support, or most people are in support of the responsible short-term rental businesses that are in our community for the most part. But where I see the problems, and I'm being really brief here because I've got a lot to talk about, but I'm not going to talk about it. But where I see the problems are the short-term rental businesses, because they are businesses, because they take money in, and it's a business. It's not like my house where I just live there. These businesses that are owned and run by out-of-town and out-of-state folks. And they have no local presence whatsoever for their houses, for their businesses. And that's where we run into a lot of problems, because when the police are called to these houses for noise issues or other issues, there's no one there that's in charge. There's nobody there to cite any, you know, any warnings to or anything like that. And the house that's next to me, and there's other ones in Sunapee as well, but this one in particular next to me, the owner lives out of state. When we had the school bus, you know, show up that Jim Luther was talking about in front of the house with 38 students from Harvard there for a retreat for a weekend in a 9-bedroom house. The owner of that house, who lives out of state, was actually in Seattle at a wedding and not responding to anybody. And so there was nobody in charge. And there's just big issues when you have, especially big houses, and lots of people there and parties all the time. And the owners, you know, they don't have a management company. They don't live on site. They don't live next door. They're away. So that's something that I would like to see reflected in some sort of bill, or, you know, that you guys are looking at, is who's in charge, you know, and who's responsible. And also with that, to have really strong penalties when there's issues, so they don't just blow it off, because they are blowing it off, at least in my experience they are. The other thing that I'd like to ask you to really take a look at, you know, there's a lot of things that other folks have talked about, which I won't even bring up because I agree with a lot of them, is the other issues that are coming into play with our natural resources. You know, the taxation of having so many people on our lake, in our harbor, on our beach. You know, our Sunapee Beach, our town beach, is a small beach, and groups of 30 people from one house go into this beach. So I think that there's some ways that the town can manage some of these things, but I also like at the state level for you guys to take a look at that as well. And the last thing I'm going to mention is the occupancy. That's an issue. There's nothing in any ordinance that I'm aware of that really manages the occupancy in these homes. So I have a 9-bedroom house next to me. There's 38 people there on a weekend. Yeah, yeah, yeah. So that was my last point. It's just the occupancy in trying to manage that. So thank you very much.
Thank you.
All right.
Anyone else wishing to speak?
Senator French. If there's anybody that drove down from Conway that's mad at you, it's me.
Nice, welcome.
Thanks. My name's Tom Reed. I live at 29 Champney Road in North Conway. Been living there since December 2014. A couple years after I moved in, you know, I'm retired. I just figured my life was going to be mowing the lawn and going skiing. Next thing I know, I have Animal House in my backyard. In a residential neighborhood, the zone residential agricultural. It's 2 dead-end streets. And now we have Delta House in the backyard. And nobody in the area is happy about it. To get a little bit quicker, to answer your question about non-conforming uses, in the town of Conway, if you had a short-term rental that predated the adoption of our present zoning ordinance, it's a non-conforming use and you can continue it. As to takings, the United States Supreme Court decided in 1926 in a case called City of Euclid, Ohio. In law school, they actually refer to it as Euclidean zoning. How obscure. They decided zoning was not a taking. Similarly, Judge Ignatius, when dealing with the recent litigation with Kearsarge's lighting precinct, addressed the same issues. These are not takings. I got to tell you, it's a slippery road for you to be involved in the minutia of municipal zoning. And I'll tell you why. When you passed the 1983 enabling acts to allow municipalities to implement zoning on a wide-term basis, you said straight out, and I sent you this as attachments to an email, you said straight out in the one statute for 3 paragraphs about zoning should be left to the municipalities. That they're the ones that are best able to deal with the growth of their towns and to adopt regulations and ordinances to deal with the ongoing problems they may have, okay? So then there's a concept of home rule. We won't even go into that, but I bet everybody here at one time or another, either on the campaign trail or on the floor, said something about home rule and the importance of it. I know, crazy. And this is, when you think about it, a home rule issue. Because keep in mind, I'm not a lobbyist, I'm not a realtor, I'm just Joe Blow. I'm one of like thousands of affected people in the town of Conway who have no economic interest in the outcome of this, okay? Not a thing. The only thing we care about is quiet living and the integrity of our zoning ordinance. Bill had a real good comment about how these things have had an adverse impact on neighborhoods. We have one particular subdivision called Birch Hill, which has gone from families and kids to where now every other house is a short-term rental. The town of Conway has not reinterpreted anything. And I know this firsthand because I was the biggest pain in the butt about the entire thing. Because I was the one that actually sat down, read the zoning ordinance, and tried to figure out how it is that Delta House can exist in my residential neighborhood. And the only thing I found was, well, I can tell you this. You can have an STR in a commercial district. You can have it in a mixed district in downtown North Conway. You can have it in an industrial zone if you want. But it didn't meet the definition of residence in our ordinance when it came to the definition of RA zone, residential agricultural. It just didn't fit the definition. I brought this up with our town zoning ordinance, our town zoning officer, and he just hemmed and hawed and quite frankly didn't want to deal with it. And yeah, shame on the town for not jumping on this earlier. But everybody, you know, people are telling me, oh, this has been around for 100 years. Not in these numbers, not when it's over 500 properties, no way. I lived there in the mid-70s. It's not the way things work. We had 10,000 people in the county. Now we have 10,000 people in the town. Much has changed. It's the internet that's just made this flood. So they really didn't deal with it. You know,
Yeah, I know.
Some of us finally convinced the town that it's not allowed or permitted in the residential agricultural zone. The town hasn't banned it. I was on the committee along with Mr. Turner in the back, the tall guy there, and Mr. Thibodeau. on the committee where we worked all during the summer of 2020, and we were going down the middle line as best we could, and proposed a warrant article that would allow short-term rentals in the RA zone. And we would talk after meetings about, how do you think the public, thinks of this? And honestly, I had no idea. And boy, I was shocked. It was defeated like a 3-to-1 ratio. It was really surprising. So the indication is that leave it to the town. Let the town make their own decisions about this. The selectman from Bristol, when he started talking about how he didn't think he had any power versus Concord, quite frankly, home rules in the state constitution. There's a statute that enables, repeats it. You yourself said in '83, we'll leave it to the towns. Let them figure it out. The fact that there might be litigation going on, well, that's life, okay? There's litigation everywhere. Anybody that has a filing fee in their pocket can start a lawsuit. And by the way, Judge Ignatius decided the Kearsarge Lighting District case in favor of the Kearsarge Lighting District. She upheld their zoning that said that you can only have a short-term rental if it was owner-occupied, because that's the way their ordinance was written back in the 50s. Like, I think it was before I was born. Oh, yeah, think about it, Senator. They were really ahead of the curve. As to, I gotta tell you, I'm not as mad at you now that I've seen your amendments at lines 13 and 15.
Oh, good.
I'd probably not like,
Just disgruntled?
well, I'm not gonna slice your tires. But it's a good improvement, I'll tell you that. Go ahead.
I appreciate you coming down. I've got to close the
Yes.
meeting. I'm glad you had a chance to speak, and
Yeah, yeah.
could,
You want to hear from Mr. Turner?
Graydon Turner, I'm the president of the White Mountain Board of Realtors. I want to thank you for your work on this bill. It's been going on for quite some time, and I commend it. I think the towns need to have the ability to regulate what the towns need to regulate. Thank you very much.
thank you. And for all those who came that wanted to testify, I was missing a paper. I would have limited the talking points had I known that we had so many. So I've got a motion to adjourn by Senator Bradley, seconded by Senator Kavanaugh. All in favor? Aye. Thank you.